Legislatures. We also wish to greet Honorable Minister Ngalele Sogalis, Inkosi Buthelezi, and the entire team led by the DG Yoliswa Makasi, Yoliswa Makasi, and our administration from Parliament that is present today. We are going to utilize the few minutes before 10 o'clock just for introductions so that we'll all know who is here. We'll start, I normally start on the left-hand side, but which is the safest side, but let me start on the right side today for today's purposes. We'll start from this side. We'll just introduce ourselves, the provinces or the structures we represent, and our positions. Then we'll move to the other side. Thank you very much. Let's start with that exercise.
Morning,
Or let me
Chair.
start with myself. Let me not assume that you know the chair. I'm Olis Kaunda, the permanent delegate from KwaZulu-Natal province, representing African National Congress. But when we are here, we work as a collective. I just wanted to raise that so that you know where I come from. Thank you.
Good morning, Honorable Chair, honorable members, the officials from the department, officials of the NCOP, and everybody else. My name is Pumelelo Saziwa, the chairperson of in the office of the Premier in the Eastern Cape. Thank you.
Good morning, Chairperson, honorable members, the administrative staff, all stakeholders present. I'm Nomasingisi Konza from the Eastern Cape Provincial Legislature. I chair CoGTA, the portfolio of CoGTA. Thank you.
Good morning, Chairperson. My name is Daniel Nkosi. I'm from the Mpumalanga Provincial Legislature. I'm the chairperson for the CoGTA Portfolio Committee. Thank you very much.
Good morning, honorable members. My name is Solima Bebu. I'm the permanent delegate and the NCOP from the Northwest Province. Thank you. Ke a leboga.
Good morning, Chair. I'm Benedicta van Minnen. I am from the Western Cape Provincial Parliament, the Chair of Premier and Constitutional Matters, and I'm from the DA. Thank you.
Oh, do you have a mic? Nama awuna umpopo.
Ampopo benga
Nama usebenzi.
benga uboni yaxesha.
Uyasebenza manje. Okay.
Uyasebenza sihlalo. Ngujabulane wakanzimandi. Permanent delegate from Gauteng. Ki representa ke lento le othiwa isijula. Umkhonto ongahlabi uyahlikiza ngiyabonga.
Okay. Next member.
Hello,
Yes, Doc.
Igor Skierkogel, NC Permanent Delegate from the Free State, representing the Democratic Alliance.
Good morning, Chair. Good morning, all. Rikus Baardnorst, Permanent Delegate, Western Cape.
Good morning, everybody. My name is Mandla Peter. I'm the permanent delegate from the NCOP. I'm representing from Eastern Cape. I'm representing UDM. Diabonga.
Medicine, Ndingumandisa Majesini from Free State, representing economic freedom fighters. Thank you, Chair.
Good morning, Chair, and honorable members, honorable Minister, and colleagues. My name is Khanya Ceza. I'm a permanent delegate from Mpumalanga, representing the red overalls. Thank you very much. The EFF.
Goeiemôre almal. Good morning, everybody. My name is Tammy Briet. I am a permanent delegate from the Free State and I represent the Freedom Front Plus.
Good morning, Honourable Chair, Honourable Members. I am Theo Baer. I'm representing the Freedom Front Plus and I'm also the Chair of CoGTA in the Northern Cape Legislature. Thanks.
Thank you. Let's move that way. Let's start there, right at the door. You can use your rally voice or church voice. At least the chair is protected. Thank Can you raise your voice? Try a little bit. Thank you.
Good morning, Chair, honourable members. My name is Shamila Abrams. I'm the PLO in the Office of the DG DPSA. Thank you.
Good morning, Chair and honourable members. My name is Tilushni Gangan. I'm a parliamentary legal advisor.
Good morning, Chairperson. My name is Tilana Halley-Starkey, and I'm also a parliamentary legal advisor.
Oh, you can use your mic.
Good morning, Chairperson and honourable members. My name is Vatiswa Somlota from the Office of the Minister, PLO, Parliamentary Office. Thank you.
Good morning, Honourable Chairperson, Honourable Minister and honourable members. My name is Pat Libenya in the Office of the Minister.
Good morning, Chairperson, honourable members and support staff. My name is Marlene Naya and I chair the CoGTA Portfolio Committee in KZN. Thank you.
Good morning, Chairperson, honourable members and colleagues. My name is Yoli Swamakasi. I am the Director General, Department of Public Service and Administration. Thank you.
Chair, good morning to your good self and all members. My name is Umzamo Botelezi, and I realize that the chair, when the legal advisors present themselves, he mentioned that he's very much protected. So since I'm from KZN, I will enjoy that protection from the chairperson now.
Good morning, Chair. Good morning, members of the committee. My name is Renisha Naidu, and I am the Chief Director, Legal Services, leading the legislative program. Thanks.
Good morning, Chair and honourable members. My name is Amkelani Paloi. I am in the DPSA's Legal Services. Thank you.
Greetings, Chair and the honourable members. My name is Gukumabuz. I'm the legal advisor from Mpumalanga Legislature.
Good morning, honourable members. My name is Lubega Mtileni. I'm the Committee Secretary for Public Infrastructure.
Honourable members, my name is Nsepeng Babusing from the Northern Cape Provincial Legislature. I'm the Committee Coordinator. Thanks.
Morning, honourable members. My name is Mariette Besson. I'm the PLO for the Free State Legislature.
Thank you. Manel.
Good morning, honourable.
Use your mic. Unampopona.
Good morning, honourable members, honourable minister. My name is Moses Manele. I am the secretary to this committee. Thank you, Chairperson.
Thank you. Thank you very much. I think we have covered everybody in terms of introductions. Without any further ado, let me start by thanking the Honorable Minister for making it a point that you come physically to the committee. This is our first interaction. We wish to congratulate you for your appointment in this very critical department in our land. We understand it's one department with seasons, some different seasons, and there is a season that always make you sweat. We wish you everything of the best in executing your responsibilities and together with your administration team and your advisors. We also wish to thank our colleagues from provinces for having taken your time to come here and be with us when we invite you, and we really appreciate your presence. Honorable members, without any delays, we are now going to be dealing with both the Public Service Amendment Bill and Public Service Management Bill from the department, and we'll have deliberations immediate after presentations. All of us from legislatures, from the NCOP, will fully participate in terms of raising questions, comments, and also understanding the processes that will need to unfold after this exercise. We are going to be having CoGTA joining us immediate after Public Service and Administration, and we'll be dealing with those bills that are before us. So we are a committee, Honorable Minister, that is a select committee that is too broad. We deal with CoGTA in its entirety. We deal with public service and administration, human settlement, and water and sanitation. So it's the biggest committee. We know the other committees are also big, but this one is also too big in terms of its responsibilities. We are looking forward to work with you, Honorable Minister, and your team to ensure that we play our oversight role over the work that we are doing as the executive, and ensuring that there is public involvement, and we pass laws as the process that we are currently engaged on. Most of the bills that are forwarded to us as honorable members serving in this select committee are part of the work that was done during the sixth administration. So therefore, when you come to new office, you inherit everything. The outstanding work, the progress that have been achieved, and the every liability that you may think of. So we are happy that we are now beginning with the process in ensuring that part of our core responsibility on passing laws, we are starting to intensify the work in that regard. But there are processes which legal will also guide us in terms of how these bills were processed and how we are expected to meet the timelines of these bills. All the bills, in processing them, we are expected at least to spend the limit of 30 months. So we'll have to do our work, and for those which have already been processed, we'll have to look at how the processes will unfold to finalize them. But for those which will be initiated as well, we'll have to follow all the processes and the timelines that are before us. So we are now going to be handing over to Honorable Minister to lead the team as a political head on the first bill that will be presented before us. Over to you, Honorable Mteles.
Ngiyabonga kakhulu Sihlalo. Thank you very much. for the opportunity that you have given us to appear before yourself and your committee to present these two bills to the Select Committee. We also appreciate the fact that this is our first meeting, as we have said, and we congratulate yourselves and the members for being appointed in this committee. Also appreciating exactly what you said, that this committee is very big, but I would like to take it further and say, not only big, it's also complicated, if not troublesome too, because it deals with all the matters that are really of concern to our people. So I think it is also important, before I hand over to the administrators, to appreciate the importance of the servant administration in the history of our democracy, Honorable Chair. But most importantly, the fact that in the revised government priorities, our department, which is the one that we are exercising oversight over, has been identified to be central as the third priority. So our responsibility, therefore, is to build a capable, ethical, and developmental state, which puts us at the center of all government activities. All our ambitions, our endeavors will never materialize if public service does not do what it's supposed to do. I always say we do what the heart does to the body, and we dare not fail in our execution of the mandate. So, Chair, policy proposals for legislative amendment by the department were presented to the Cabinet in 2020, and the main objective of this bill were to improve service delivery through the alignment of human resources, governance, and related arrangements in the three spheres of government to achieve specific objects as they will be outlined by the team. Honorable Chair and members, as we are all aware, and we have actually mentioned the fact that this bill is revived from the sixth administration, meaning that so much work has gone into it. However, Chair, I want to ask members of the Select Committee to really apply their minds in this bill and pay specific attention and not simply take it for granted, the fact that it is a revived bill, so we should take it easy and rush it. So they must give themselves time, because there are some areas, maybe there could be some areas that need to be fine-combed. As we all understand that our government has been through some difficult situations in the past. So some policies and legislative interventions were enacted to deal with specific situations. Sometimes, having done so, you realize that maybe we need not have intervened in that fashion. We should have instead dealt with specific individuals as opposed to enacting some legislations to address such. So I'm inviting, therefore, members to feel free to engage on this and apply their mind thoroughly, as you have alluded yourself, Chair. So without wasting much time, with your permission, I will then ask to hand over to the DG and the team to present the actual bills. Thank you so much, Chair.
Thank you, Minister. Good morning once more to the Chair and the honorable members. Chair, I will just take the first part that addresses the context, and then the technical team from DPSA will take you on the detail of the proposals that are coming out of the bill. And just from a point of view of context, I started work in DPSA on the 2nd March 2020, and the bill was already in the pipeline in terms of the policy work that was being done in the department, as the legislative amendments were part of the MTSF priorities, the medium-term strategic framework priorities that had been approved in October 2019 by the new administration at the time, which was the beginning of the sixth administration in 2019. And so far, the progress to amend the Public Service Act 1994 and our Public Administration Management Act 2014 were initiated in 2019, as I highlighted. The bills adopt a holistic approach to public administration, looking at pillars of public administration, and the key pillars that really are guiding this work is the citizens, because for us, we must always answer the question, how do citizens benefit from public administration? So we are not in existence for ourselves in office as public servants, but we exist in order to ensure that there is delivery of quality services and that we serve the citizens. From a government point of view, how does government meet its obligations to the citizens of South Africa? In terms of the service, how the public administration renders the service to meet the demands of citizens and ensure that government's obligations are fulfilled. And the fourth key consideration is really about as well the employees in the public administration, in the sense that what is expected from public servants to ensure that the service is properly rendered. So the issues of professionalization, the issues of an ethical public administration, the issues of integrity are also part of those expectations from public servants. So as I indicated earlier on that amongst other, if you look at the genesis of this work, the National Development Plan is actually one of the key drivers, because the National Development Plan did an assessment and highlighted some of the work that or interventions that need to be done within the public service and issues around the professionalization framework and etc. are issues that are coming out of the National Development Plan. So this work has that genesis as well in the National Development Plan. There has been changes in labor legislation and policies, and colleagues will outline those in detail. And also there is the bigger objective of the single public administration and initiative that DPSA has been working with CoGTA on, and amongst other institutions, and the professionalization framework I highlighted earlier, as well as the response plan of the President to the Zondo Commission report. The DPSA is part of the team that's working on the responses to the Zondo Commission report, just to also how we strengthen anti-corruption initiatives within the public service as well. If we move to the next slide, which is the last slide for me, just in terms of the processes, we highlight some of the critical stages and processes we have worked with this bill, with these two bills. Firstly, we published for public comments in the Government Gazette on 6 April 2021, after all the policy issues had been approved by Cabinet. And then there were extensive public comments that we received, especially on the Public Service Amendment Bill in particular, and I think we should acknowledge some of the departments that made inputs, in particular the Public Service Commission. They made extensive inputs, also informed by their research and investigations that they've been doing on a number of areas affecting the work in the public service. The bills were extensively consulted at the relevant bargaining councils, in particular the Public Service Bargaining Council, which deals with, amongst others, conditions for public servants. And we actually took almost, I think, a year in consultation at the level of the bargaining council, of the bargaining council. I remember one time we had to send the legal team to read word by word all the amendments and to enable the discussions at that level. So there were quite robust discussions and inputs. Then we had to take the bill to NEDLEC, and engagements in NEDLEC also took, I think, around 6 months, and NEDLEC really also made inputs, and we agreed, and they actually agreed at the end on the redrafted bill, and we submitted the bill to Cabinet on the 31st, no, to Parliament on the 31st of March 2023, and the Portfolio Committee made 2 changes. A list and adopted the amendment bill on 14 February 2024 and referred it to the National Assembly. The bill was adopted by the National Assembly with the amendments on 27 February 2024 and presented to the NCOP which is the bill listing now. The bill was revived and referred to the Select Committee on Cooperative Governance and Public Administration on 30th July 2024 by the NCOP following the elections. So this is where we are currently, hence we are here in the committee, and we will then take cue from the committee in terms of support required from the department as the process moves forward. With that, Chairperson, with your permission, I'd like to hand over to our Chief Director, Legal, together with Amu. I think the first bill, the presentation is by Ms. Amukelani Baloyi, who will take the committee through the policy issues and some of the problem statements we are trying to address through those policy interventions. Thank you, Chair.
Thank you, DG. Before we allow the legal team to present, I omitted 2 apologies. The first apology from the whip of the committee. She'll be joining us around 11:15. And we also received an apology from the chair of Free State, who's on his way, if it's his or her way. So we take those 2 apologies, members, and record them accordingly. Yes, yes.
Thank you, Honorable Chair. We also wanted to apologize on behalf of our legal advisors. Their flights have been delayed. They'll be joining the meeting during the course of the proceedings. Thank you, Chair.
Okay, thank you very much. Those apologies are noted. Let's hand over through you, DG, and the Minister to the team to present.
Thank you, Chair. Good morning, Honorable Chair, Honorable Members, Honorable Minister, DG, colleagues are present here. I will be taking the committee through our presentation on the Public Service Amendment Bill. The first proposed amendment is in clause 1 of the bill, where we are proposing amendments to definitions. We are proposing an amendment to the definition of executive authority. We already have this definition in the Public Service Act. However, there has been confusions in terms of who is the executive authority when it comes to the heads of departments. So we are rewriting this definition just to clarify that the president and the premier are the executive authorities in relation to heads of departments. We are also proposing an amendment to the definition of head of department. Currently, the definition that we have in the Act of head of department includes, or rather it refers to people who are acting as HODs. This has caused a misinterpretation of this definition, Chair. So we have removed reference to acting, just for clarity. We are adding a new definition of political office, and this is for purposes of clause 15 of the bill, which we will talk to when we get to it. And we are inserting this definition for political office to mean the position of chairperson, deputy chairperson, secretary, deputy secretary, or treasurer of a party nationally or in a province, region, or other area in which the party operates. And Chair, we have also made provision to cover these positions in political parties where they're not referred as chairperson and deputy chair secretary, deputy secretary, and treasury. In her introduction, DG spoke to the proposals of the NDP. And one of those proposals, Chair, referred to political administration interface and how to remedy that. The NDP has raised issues regarding political administrative interface and the instability that it causes within the administration. And the solution to this is to have a clear separation between roles of political office bearers and the administrative heads in departments, and we are giving effect to that proposal in the bill. One of the or rather the things that we have identified, Chair, that will address the challenges as raised by the NDP is when we vest administrative powers with HODs and vest strategic powers with executive authorities, it will help in the administration in that executive authorities will be unburdened with the routine day-to-day administrative matters. Executive authorities will be better placed to deal with strategic matters and fulfill their constitutional obligations. When the administration of the department is vested with the head of department, it makes decision-making easier for the head of departments. Currently, Chair, the PFMA gives financial responsibilities to the HODs, and we are proposing that we align the financial responsibilities of HODs as provided for in the PFMA with administrative powers in the Public Service Act. Also, the NDP has identified that some of the tensions that usually arise between executive authorities and heads of departments are caused by the fact that administrative powers lies with executive authorities currently, and they are dependent on them being delegated to heads of departments. So if these powers should be vested with the heads of departments, then it would manage that conflict and tension. Heads of departments, Chair, are accountable for the output of their departments. So it is our view that when they have administrative powers, they will be better placed to manage departments. We have created a graph here, Chair, just to give a picture of what we are proposing. And it will be my left side from where I am sitting, where we have outlined the powers of the executive, being the president, premiers, ministers, and MECs, as well as deputy ministers. In terms of the constitution, Chair, they have powers to coordinate the functions of the state's departments and administration for preparing and initiating legislation, implementing the legislation, developing and implementing national or provincial policies, as well as performing other functions. These powers will remain intact as they are guaranteed by the Constitution, and ministers and MECs will continue to exercise these powers as provided by the Constitution. On the right-hand side of the graph, Chair, we are trying to give a picture of what we are proposing in the bill. We have the powers that are already vested in the HODs in the dark blue colors. So currently, in terms of the Public Service Act, HODs are responsible for utilizing and training staff in departments. They are responsible for labor relation and discipline management, so that will stay. We are proposing that the powers that are in the light blue color should be vested with HODs. Currently, they are vested with executive authorities, and in the bill, we are proposing that these powers should be vested with HODs, and that is the powers for recruitment and employment of employees, remuneration and career incidents of employees, performance management, human resource planning, approvals of work outside of the employees' employment in a department, organizational structures and establishments, as well as transfers of functions within department. And we are also proposing that dismissal or retirements of employees should be vested with the HOD. We are proposing further, Chair, that the approval of the strategic plan as well as strategic powers should remain with the executive authority. To give effect to this proposal, Chair, we are amending Section 3 of the Public Service Act, and here we're giving executive authorities the powers to be accountable for the functional areas of their departments. And I would like to pause here, Chair, and just make an example. when we are referring to the executive authority as the Minister for Public Service and Administration, they will retain their powers to set norms and standards in terms of the Public Service Act. So that will not be affected, and this applies to all the other executive authorities. They will further be responsible for approving strategic plans of their departments. They will have the power to ensure that heads of departments fulfill their roles and responsibilities, and that these roles and responsibilities are aligned with the strategic plans of the department. And they will also have the responsibility to establish relationships between the heads of department and other employees, as well as to facilitate and coordinate these relationships and communication. Executive authorities will continue to hold heads of departments accountable for the administration of the department, and will also exercise other powers and perform functions which are imposed by the Public Service Act on executive authorities. Because we are proposing that administrative powers be located in HOD's chair, we had to put checks and balances in the bill just to make sure that as we vest these powers with HODs, we leave executive authorities with certain powers. And we are proposing that the executive, or rather the head of department, should report to the executive authorities as and when they are required to. That the head of department should assist the executive authorities in fulfilling their executive accountability obligation in terms of the Constitution. And we have also made provision for instances where an HOD fails or refuses to fulfill these administrative powers. And here we are saying that the executive authorities must intervene in these instances, and where the HOD continues to fail to fulfill their powers or perform their duties, then the executive authority can report this failure to the president or the premier. When we went into Parliament with this provision, Chair, we had drafted it in such a way that the executive authority had a discretion, so we used the word may, and it was amended during the parliamentary processes from may to must. The suggestion is it must not be discretionary. The clauses in the bill, Chair, that will be affected by this proposal of vesting administrative powers with the HOD are the clauses which are outlined on the slides, and they are amending sections which deal with powers of the currently executive authority, which are being vested with the head of department. And you will see, Chair, it's sections 3.7, sections 3.8, section 9, 13, 14, 16, 16B, and other sections which deal with the termination of employment of employees, and as I've mentioned in the previous slide, remunerative work by employees, as well as payment of remuneration and other matters. The next proposal we're making in the bill, Chair, also emanates from the NDP, where the NDP is proposing a creation of the head of the administration, and the proposal is that this head should be located in the presidency. So we are proposing an amendment to section 7.3 of the Act, where we are giving the following powers to the DG in the presidency to create the head of the public service. And we are proposing that the DG in the presidency, in addition to other powers which are outlined in section 7.3, is secretary to cabinet, that they coordinate the FOSET, that they are responsible for intergovernmental relation, and that they support the president in matters which are entrusted or assigned to the president by the Public Service Act and any other law, and that they perform any function if they are requested by the president, and this is subject to the Constitution and other laws. Chair, the NDP further proposed that we should have a similar provision for the DG in the Premier, of the Premier. However, we did not do this amendment as we already have a provision to deal with this in the Public Service Act. In the next slides, Chair, we will take the committee through the technical amendments that we are proposing in the bill. The first is reflected at clause 18, where we are proposing an amendment. When Ms. Naidu takes the committee through the PAMA bill, she will talk to the repeal of Section 15 of the Public Service Act. Because of that repeal, we are proposing here that we retain Section 15(1) of the Public Service Act, which deals with the continuation of benefits for employees who are seconded from organs of state, and it offers a protection on those benefits. So we are proposing that we retain that section as Section 15(1) is being repealed by the PAMA. We are proposing an amendment to Section 16 of the Act, which is reflected at clause 9, which deals with retirement. Previously, the Public Service Act used the term officer instead of employee, and when it was amended, there was an omission where Section 16 was skipped, so we are correcting that to remove that reference to officer and replace it with employee. At clause 13, Chair, we are proposing an amendment to Section 31, and here we are just correcting the reference to the Commission, being the Public Service Commission. We are correcting the reference to the Constitution, as well as an incorrect reference to Section 30 of the Act. We are proposing amendments at clause 14 of the bill, where we are amending Section 32 of the Public Service Act. We are not bringing anything new here, Chair, just cleaning up the provision, which deals with reassignment and acting appointments. And here we are clarifying the powers to appoint persons for reassignments and acting appointments. And we are proposing that reassignments and acting appointments be limited to the department, or either within the department. In terms of reassignment, we are proposing that the power to reassign a head of department be vested with the executive authority, and that the head of department should have the powers to reassign any other employee. In terms of acting appointments, we are proposing that an employee who's occupying a position should have the power to appoint a person to act in their absence. In case of a vacant HOD position, Chair, we are proposing that the relevant executive authority should have the authority to appoint a person to act in this position after consultation with the President or the Premier. And in case where there is a vacant post below the Director General level, we are proposing that that authority to appoint be given to the head of department. We are proposing an amendment to Section 35, which deals with grievance procedures, and this is reflected at clause 15 of the bill. Currently, Chair, the Public Service Act makes reference to rules, grievance rules by the Public Service Commission, and we are clarifying that provision where we are separating external grievance processes, which is the responsibility of the Public Service Commission, from internal grievance processes, where we are proposing that these rules should be determined by the Minister for Public Service and Administration. In the first slide, Chair, I referred to this insertion on the limitation of political rights, where we inserting a definition for political office. This provision is currently not there in the Public Service Act, and we are proposing that we insert it. And here we are limiting political rights of heads of departments, as well as employees reporting directly to the head of departments. Chair, Section 19 of the Constitution guarantees every citizen a right to have political rights. And in terms of section 36, this right can be limited if it is justifiable. We are proposing a limitation on this right for HODs as well as employees who report directly to HODs. And the reason for this, Chair, is we want to try and manage conflict of interest between political parties and the administration. It could only be justified for us to limit it in terms of heads of departments and employees reporting directly to heads of departments because of the conflict of interest they have due to the positions that they occupy. And the intention here, Chair, is we want to ensure that there's a clear demarcation of politics from administrative roles and responsibilities. We are proposing an amendment to section 38(2)(b)(1) of the Public Service Act, and this is reflected in clause 18 of the bill. This provision was declared unconstitutional by the Constitutional Court, and this provision, Chair, it deals with the recovery of overpaid remuneration. And after the Constitutional Court, we had to amend this provision to align it with the Basic Conditions of Employment Act. And we have set mechanisms in place to ensure that when we recover overpaid remuneration, we do not undermine the rights of employees. And the proposed amendment is that overpayments should be recovered with the consent of an employee, and where there's no consent, we should recover by way of legal proceedings. We have made provisions for instances where an employee moves from one department to another. We further made provisions, Chair, for instances where we need to recover from an employee who is no longer in the employ of the state. And we have aligned these provisions with the parameters of the Basic Conditions of Employment Act in terms of the deductions that will be made. At clause 19 of the bill, Chair, we are proposing an amendment to section 42A of the Public Service Act, which deals with delegations. As it is currently written, Chair, it refers to the powers of the President to delegate matters relating to the appointment and career incidents of a head of department to the Deputy President and a minister. It has caused a bit of confusion because minister is defined in terms of the Public Service Act as the Minister for Public Service and Administration. However, the intention is to give the President powers to delegate to any minister. So we are amending this provision to remove reference to minister, and we are replacing it with member of cabinet. At clause 20 of the bill, Chair, we have the short title and commencement. And this clause basically says that this bill will be referred to as the Public Service Amendment Bill 2023, and it will come into effect on the date determined by the President. This brings me to the end of my presentation. Thank you, Chair.
Thank you very much. You did very well in terms of time. Would like to welcome the presentation on what the bill intends to achieve. Let's then allow, if there are additions from what you have presented. Is the team covered, DG?
No additions from my part, Chair, thank you.
Let's then allow members to ask questions, clarities, make comments. You combine all those three. Honorable Eza, you are the first. Honorable Zimandi, you are the second. Honorable Peter, you are the third. Honorable Makesini, you are the fourth. Leadership, you are the fifth. The sixth. Any further comments? Yes. Honorable Saziwe, you'll also follow. Thanks. Can we then start in that order? We do not intend to incur fruitless expenditure. So what has been provided here is for you to consume. So otherwise, we'll be in trouble with Auditor General. Please, Honorable Minister, we have provided everything here. We know that resources are limited. Okay, let's start with Honorable Kaza. You know our rules in terms of how we deal with these issues. I'm not going to be pressing you. Thank you very much.
No, thank you, Chair. Thank you to the presenter. I think that we should welcome the presentation and welcome the intent of this bill, Public Administration Management Bill, on the basis of professionalization of the public sector, one. And secondly, on the issues of corruption, two. And thirdly, on the issues of transparency, but also on the issues of staff retainment. If you look at where we went, Honorable Chair, in Tabazimbi, we've got parallel structures there, 3 PMTs. And therefore, it makes it difficult for the MEC to then hold the executive to account or even meet that executive, because there exists in the public sector a situation where there is total dysfunctionality and decay of governance. And I just wanted to ask in relation to slide 15, ngexesha Eastern Cape, siqala utya emsileni inkomo. Qala apha ekugqibeleni. You speak about the recovery of overpayment from the person no longer in the employ of the state, requires legal proceedings and by deduction against any monies owed by. I just want to know that the period of reaction to that, because I can imagine if I'm no longer employed as in the public sector, and then the monies that should be recovered that were overpaid, I can no longer afford. And then there's legal action that is taken against me. And then I ultimately get arrested. And then does arrest or legal action mean that when you have arrested, the department has actually recovered the money that was supposedly was supposed to have been recovered? I just want to get an understanding there. And then, Chair, sorry a bit, while I'm perusing, just in a nutshell, how would you explain this to the layman? How would you say, what would you say the bill seeks to achieve? You are telling a layman now, a person that is from the communities, because if the communities do not understand the legal language, it is a futile exercise. That's my question. And I'm in support, Chair, of the manner in which the bill seeks to deal with these matters, because across all sectors, I mean all sectors meaning the departments where we are serving, there are all these issues. Some of the issues are just technical. There you change a name from employee from officer to employee, which is quite technical and human resources based issues. But let me just go to the issue where I really want to ask a question, which is my last question, Chair. There in slide 5, You are speaking about Chapter 3 of the NDP of 2012, and you speak about the diagnostic reports indicated uneven performance of the public service in local, provincial, and national government. And then you state the interface, the political administrative interface, and so forth. I am wondering if that would also entail the question of institutional memory and staff turnover, and what becomes the solution there. Yeah, that's about it, Chair.
Yeah, that was the last one. Thank you. Honorable Nzimande.
No, thanks, Chair. Firstly, we want just to submit that...
You must start by declaring that you come from public service. You can proceed.
We want to submit that we support the notion of a unified public service, a single public service, but not at all cost. The first matter of concern, which I believe may be clarified, is that why this proposal seek to undermine principles of law of contract when it comes to the issue that deals with transfers. The law of contract is clear. Employee puts their services at the disposal of the employer. It's the employer that determined. Now, when the bill starts to say that will be subjected to consultation and it ends there with no definite position, it means then you only allow the court to intervene to that space to deal with that, depending on what kind of a president you have, whether he's a Darling to Stellenbosch. That's a major problem. You need to be definite and stick exactly to what the law of contract deals with. If I am employed, I have to put my services at the disposal of the employer. If the employer disposes my services is the employer's right and the obligation in terms of the contract of employment. That's one aspect. But the second aspect then deals with the issue of secondments. Has the department applied its mind on the effect of the tensions this may lead to? Because you may have people performing similar functions as the other one is seconded, the other one is employed at a different layer of government, or sphere of government, and the salaries are different. But you are asked to go and intervene as seconded and retain the benefits you have, which could be not equal or similar to people that are ordinary performing such function at that particular level of government. But the third part is in relation to why will you find it so important when you have already clarified the functions between the executive authority and the accounting officer, to say a person, constitutional right must be taken away to be a political office bearer? Because that particular individual would be operating now clearly within the confines of the operations. Why is that so important that it be part of this? Because we have clarified somewhere else in that. But the last part, Chair, then deals with the question of the tension which this law seeks to introduce now. There's only one person voted, is the executive authority, the MEC or the president, and his own party. The the act or the bill that is being suggested is that the role that they will have will only be ending at the strategic level. But the structures and all other resources are informed by the strategy. The problem is, if that power is solely confined on the accounting officer, with the hope that the accounting officer's responsibilities will try to pursue the issue of the political mandate. And if there's a different of opinion, no, you'll go with the cap in hand to the premier as an MEC and say, please intervene. And the act is silent to say how far that intervention can go, which is the major problem. Now, the other problem which arises in that is that you have now a new dimension of coalitions which might be with us for some time. You'll have a premier who's having a different political party and the mandate or policy positions that he wants to pursue based on his own party, irrespective of whether the president is a different party. And the MEC also having the different one. Are you not really creating a problem in terms of service delivery that you have seen in local government, currently in these coalitions, where some municipalities are not functioning on the basis of political tensions that are created by such environment? Thank you.
The next member is Honorable Peter, followed by Honorable Makasine and Honorable Kos.
Thank you, Honorable Chair. South Africa needs a man and a woman who are strong enough to make laws and pass bills of this country. We are far behind to make our laws effective. Chair, I've got only few questions, only one per se. It's dangerous, Chair, to hold the bull by its horns, because it becomes more powerful and more dangerous. It's also dangerous to eat the food that is already cooked. We don't know which corner this food was cooked and it was cooked for. The bill that is in front of us, Honorable Chair, I'm part of the GNU. First, let me address me by that, I say. But I need more clarities, because this food was cooked not to this administration. It was cooked for 2023 for the previous administration. Now this administration has to pass or approve the bill that was not part of. We don't know who was consulted then. But this bill is a part of this House to be approved. But only for clarification to this presenter, Sisi. You know, we are servicing. Why, Chair, should the seventh administration be entitled to pass or approve this bill, which was proposed in 2023? Why should this bill not start from where it was started, so that we can just start this together? Kumbuzo ke mhlambi onobudenge lo, but I have to ask it. My last question is, my appeal, Chair, to this House, let us be part of the process. Let us not be hijacked. Sinikwe document from the last moment. Esasifunda nini? Sisifuna from the week nasifundile imiqulu engaka zawuyazelaphi, because we don't want to reject the bill. We want to be part of the bill. Sakhilizwe sonke. I thank you, Chair.
Thank you, Honorable Peter. Welcome, Honorable Glut, the Chair of Free State. We received your apology. Thank you. The next member is Honorable Makasine.
Thank you, Chairperson. Let me welcome the amendment of this bill. Ukuphekwa kwayo kutya kumnandi ngoba kuyabonakala babeyazi uba kuza kwenzeka izinto ezinje. Silinganeni Honorable Peter, iGNU yena nanibonela phambili siyabulela. Ngokuhlakanipha kwenu. So the only thing that I want to check, the secondment of the official in some of the municipalities, time and again, they will, in the department, they will second an official to the department without remuneration. And they are not protected when they want their benefit, or by conflict between the executive and the administrator. For example, Chair, I just want clarity because le bill in this Sakundenzeka Free State now, where the premier will just wake up and say, I don't want this HOD here. I want this HOD to that department. But remember that official will apply because of the skill and the requirement of this department. Now, because the person is exercising her or his own right in a wrong manner, is removing people because it doesn't like people because of their own personal interest. Hence, I say we support this bill because this bill limits the powers of the politician so that for future, even if the issue of the government of national unity ibikhona, umtu with the requirement can be protected as an official to work in the department without interference because he's coming from a certain political party. I don't feel comfortable to work with that person. That's the reason the EFF feels very strong that we need to support the limitation of the powers of this executive. Two, you found also, and it's quite DG here, the issue of the acting. You found Guti, there are people that have been acting for 13 years without a point of department, but it's been on the level, we are new level up to the senior level for 13 years, which means that person, the government needed the service of that person. We need to insert a law that will protect people that have been appointed temporarily to work more than 5 years. We must say, even this bill must appoint, maybe if a person has been appointed temporarily, within a year, that person must be appointed as a permanent because we are the services that we provide as niggas as needed because why are we not removing if this person we don't need? For example, again, Chair, in Free State, we had last week in the Free State High Court, where abantu abasebenze ku departments zase Free State for 13 years were removed because the premier ufila ukuba akabafuni. Those people, they are matter now utama baye labor court. With what? Because the premier, again, the executive, they are using their own powers because they are using the money of the state to use our powers are very wrong. We must insert if the executive interfere on the process of administration, funeka illegal processes as battling ngemali yakhe. So that to avoid anyone must use his own or her powers in a wrong to feel fully political interferences up. So I really, with those things, I feel that these powers, even the issue of the secondment if there's an acting HOD, I think it's clause 18. If there's an acting HOD, we need to second a certain person to the or to the certain municipality, like normally the CoGTA is doing. That powers must not be given to the executive. That powers must be given to the DG if there is no permanent HOD, so that head of administration is held even powers to control this thing. Because now and again, abantu bayakhutshwa, bayalahlwa, and we are destroying a lot of the public service and the morale of the public services. Uba down, uba phansi kakhulu, Chair. But literally, I think if we can insert also it's into we can't have people that are acting forever. Once a person acts, which means you need their services, those people, they must be protected. and the powers of the executive, I fully agree. Makesi the control so that as much as we avoid the conflict, irole yabo mabapresent i-budget anditshenzwa strategy se-department ine everyone, all the sectors, makapresent andithi uvotelwe. After 5 years uyahamba. So that angabi namandla because base bacinge bahleli bakhile apha destroy public services. Thank you, Chairperson.
Uyithatha plan nto kulungile. Honorable Kosi.
Yes, thank you very much, Chairperson, for the opportunity. Let me also acknowledge and accept and appreciate the presentation that has been given to us on the Public Administration Management Bill. But mine will be to say that it's going to allow the members or the people in the public service to serve the people that they are paying. You know, public servants are paid through the taxes, and the public are the bosses who must be respected. We have seen in some instances that those people who are officials or who are working in the public service, sometimes they don't take that into account. Having said that, Chair, I have a question on the disparities, that is slide number 13 of the presentation, the disparities that have been cited here that this bill is going to address together with the taking into account the public parastatals or the state-owned organization, if I've read it well. I just want to get a clarity as to how is this going to happen according to this bill. So that when I'm explaining to a layman on the street, I have a clue as to how is it going to happen, given to account the way in which some of the state organs are working, or the state-owned organizations are working. Then my question will also be in slide number 7. When the officials are not allowed to conduct the business with the state, it has also been mentioned that this is also be applying to the non-profit companies. Yes, I want to get more clarity on that one, because on the non-profit side, there are these issues of the non-profit organization, not necessarily companies, as to how much extent is this going to be applied. That's all I wanted to check. Thank you very much, Chairperson.
Thank you, Honorable Nkosi. Tatu Saziwe.
Thank you, Honorable Chair. With your permission, Chair, the apology that we have forwarded on behalf of our legal advisors, they have since joined the meeting. We have Mr. Kyabazayo, who's the legal advisor for PC on Office of the Premier, Ms. Ngetia Stirmane, a legal advisor for PC on CoGTA.
They are welcome. Thank you. They must join us there. As this committee, when you come, you greet the table. I'm sure you've seen the table. So at your own time.
Yeah. Thank you, Honorable Chair. Thanks to the Minister, the DG, as well as Chief Director, for what I term as an excellent presentation of the bill. It does mean that since we are joining government, there was no government before. So no one was left behind, but those that were there had to do something. I want to start with that disclaimer first. Chair, I'll start with a request first before I raise my questions. On slide 3, I think it's 6 on those marks, where it says the committee made 2 changes as a list. which I believe those are included in the principal bill itself, which unfortunately is not part of what we have. Because part of that is that you are unable to follow the clauses if their objectives have not been presented here. So in that principal act, I think those objectives are there. I just request that we will be provided with those, Chair. The first question, Chair, relates to definitions. In particular, the proposal of having a head of public service. When you look at the definitions, that is not there. We ought to define what we mean by the head of public service. And secondly, what will be the relationship between that head of public service with the Public Service Commission? Because in my understanding that part of the work of the Public Service Commission is also to have checks and balances in how public service conducts itself. That's the first question, Chair. The second question, Chair, relates to Section 16, the amended, that seeks to amend what is currently happening in the local sphere of government, where Section 56, as well as city managers, are prohibited from holding public office in their different political parties. But I want to check, even the trade unions, we have those that are designated as public office bearers. I want to check whether then is this not also something that needs to be considered in terms of so that we have a professional public service in that fashion. That's the second question, Chair, from me. The third question that is of acting, Chair, will be, how does the bill cater for the response of the President to former Chief Justice Raymond Zondo's report? Because I thought that in the clauses, we ought to be seeing some of those being, catered for in terms of the current bill. I know every year each legislation goes under review. Maybe is this something that is in the pipeline? Number 4, I want to also check how does the bill address the notion of a single public service across the 3 spheres of government? Because it seems as if we are focusing on the national, provincial government. We are not talking about the local government in terms of this, in my view. We ought to have something that is seamless in the bill. I think my honourable member from the Red Beret has asked a question that I think I had in mind, where I'm asking, how does the bill address instances of perceived abuse of power by some of the admin heads that may lead to financial loss? Where, for instance, after a hearing, this particular person was found to be scotch-free, but this head says, no, I'm going to further appeal. That appeal gets again be approved that it was wrong. Then the Department of Government has to pay for those costs. So how does this bill then address that? Thank you, Chair.
Thank you, Obusaziwe. We now move to the Honourable Minister and the team to respond on the question raised. Honourable Skir Kocher.
Sorry, Chair.
The afterthought.
Yes, afterthought.
Okay.
It's just 2 short ones. In clause 2C, it provides for the duties of the executive authority. But it appears that there is no provision dealing with the instances where the executive authority fails in those duties. So in other words, what are the process or steps available to someone should the executive authority fail? So this stands out directly below the subclause, subsection 9. It's created where it deals with events where the head of department fails to fulfill their duties. And then the second one Clause 3 provides for the amendment of Section 5, which relates to the implementation or limitation of actions affecting to public services or its members. One concern is raised here in its relation to the wording of Clause 6, which provides that the relevant executive authority or the head of department may perform any act in connection with any matter which relates or arises from the employment or the conditions of the service of the person formerly employed in public service whilst he or she has so employed in the department. This clause is very broad and it's open to abuse. So I think one should just, it would be ordinarily in line with the rules of prescribed in civil matters. However, it should not expire when any decision can be taken in regard to criminality. So those are just two comments, Chair, that I want to make.
Thank you. Let's hand over to Minister, Honourable Minister, to respond and the team.
Thank you, Chair. I just want to address two issues and then I'll leave the rest to my colleagues. Firstly, the last question that relates to executive authorities failing to perform, that's a separate, what you call route altogether, because that's a prerogative of the president. So ministers sign performance agreements with the president, so that can be addressed elsewhere. But it's a point that is very good to make. What I really want to do here, I want to speak a little bit on the issue of Free State. And I'll remind the members of what I said earlier on, because we have brought this process to yourself. It's your process. You must actually interrogate it and effect the changes that you want to see. But also, there's a statement that I said, to say sometimes we come up with piece of legislation to address a specific problem. And later we discover that ordinarily we shouldn't have even started to do so. Honorable Chairperson, there are issues here which speaks to individual umzamo, where you need not to legislate, you need to deal with the person. Because when it comes to moving of staff, that is provided somewhere. If you know your story, you can't simply tomorrow say you don't work here, you go to that particular workstation. It can't be like that. So there are issues that we must address, which speaks to consequence management. Otherwise, we are going to over-legislate and see no effect at all. I want to draw members' attention to the following slides, so that at your own time you interrogate this. Slide 4, under definition, where it speaks to the limitations to chairpersons or people who are holding public office in political parties or otherwise. It only speaks to the chairperson and the secretary. But those are not people that are that are actually executive. It's a whole committee. So therefore, it means that I can be a deputy treasurer, for argument's sake, or an additional member who is equal influential as the chairperson, but I'm excluded here. So is that what we want to do, or we want to say the whole executive? I think that is the route, because we know that it's not necessarily about the chairperson. Sometimes you may have even the chairperson who's controlled elsewhere. Those are facts. So it's too limited here. It limits you to 2 individuals, yet they are not the ones that are only members of that particular committee. So just for you to look into that. Also, there is slide 6. Oh, slide 5. If you go to slide 5, it clearly defines a set of things, the one that is on the screen there, which seem to be an impediment to service delivery. But if you look at all of them there, and you look at the proposals in the bill, are these proposals addressing all of those? That's a question I'm posing, Chair. Also, when you look at the separation of powers now, is that the mischief? Or we are trying to address a particular problem but using a different mean altogether that won't take us there. You've got delegations of powers. So the EA does not run with the show. You delegate, there's a DG here. There are powers that I've delegated to herself, meaning she's responsible for that. Do we have to just fine-tune that, or we've got to simply say, clearly, there should be any political, what you call oversight in all this, to say management on this side and then politics on this side. That's a consideration. The same, what you call statement now, which speaks to EAs all responsible for the strategic, what you call direction. But do you come with a strategic direction, say this is where we go and you end there? If it's not implemented, you are silent now. But the same provision here, I think it's slide 8, speaks to a conflict now between the HOD and other employees. The same EA who is said not to come any closer is now invited to come and mediate. That's a contradiction altogether. And lastly, there is a clause which we need to fine-tune, which speaks to the overpaid employees, where we recover monies and we even call them to appear before court. That is fine. Does it address the mischief? What has happened there? Because we found that there is an employee who owes 200 million, for argument's sake, because someone decided to increase his or her salary by a particular amount of money. That is not the discretion of myself as an employee, but my supervisor. When 2 years down the line they discover that there was a mistake done by not myself, then I must suffer that. How much fair is that to the actual employee? Because I have been paid this amount of money by my employer who told me that I deserve so much. It's not my fault at all. It's not like there was an irregular, like a payment of some sort. No. Through the annual increment, that is how much I was given. And I was happy to say, I'm paid double now because I overperform. I assume as such. But later discover that, no, that amount of money was not due to me. Is this helping us to get there? What happens to that particular person now? Who caused that at my ignorance? So I'm bringing this to the members so that even on their own, they just look at them so that we can be able to come up with a fine bill that actually addresses the problem. And if the issue is consequence management, let us face that. Because as a country, we've enacted so many laws and so many legislations, and if you go to the local sphere, it's even worse. The most legislated sphere is local government, but are those legislation effective? We are going to say, all of us here, no, but that's not true. But specific individuals, that needs to be dealt with. I think I will end there and then allow my colleagues to actually comment. But members of the committee must look into this. That's how transparent we are, because I also take the note from a member who said, this is work from the previous administration. I think he just meant to say, we need to be more involved and more educated on this. Also, the issue that was there to say, where is the principal bill? These changes are actually made from where? So it means work has just started. We're saying this is where we are, but we must have another engagement now where we even cross-reference.
Thank you, Minister. Chair, may we proceed to answer some of the questions?
Yes, you can proceed, teacher.
Thank you, Chairperson. Chair, we'll just go through the questions, and colleagues at DPSA, specifically those two colleagues, will have to come through some of the very technical questions. I think the first question I noted related to issues around recovery of overpayment, Renisha, which you should take and answer. The other one relates to the slide on powers of executive authority and the issues around how do we build in institutional memory and staff retention. And then there's a question that I thought links to the second presentation that we're supposed to be doing on single public administration that relates to transfers and matters ending up in court because there's not been consultations. So what happens if there's no consultations? In a way, we're bringing courts into this work. And an example of the Free State Province, I think, is what is a running through theme in relation to that. And Renisha, secondments or effects of tensions in respect to secondments. I think we just need to technically explain the difference between transfers and secondments as well, and what our regulations indicate about these particular matters. There was also a question around the limitation of political rights. I think the minister has also spoken on the issue. So the question was, why are we limiting political rights of public servants who want to be active in, who want to lead in political parties, basically? And I think the response here I can give at a high level is that the issue is about roles and responsibilities. Where there is a possibility for conflict, how do we manage that? So public servants have chosen a career line of being public servants and are occupying the leadership positions in the public servants. That's why we're saying the limitation applies to the head of department, which would mean myself and the people who report to me in the administration. It does not apply across to all the officials because, of course, out of consultations and engagements that we've had also with labor and some of the inputs that we received, we had to consider that. It's really aimed at professionalizing the public service and managing the likely conflicts. When I, as the DG, I go and sit in the top executive of a political party and I'm able to make inputs on matters that may even relate to my role as a DG in a department. So we need to manage that conflict basically in terms of that, but the team can also explain further on that issue. Then there's a question around I think this relates to the role generally, the role separation between ministers or executive authorities and heads of departments. Well, I mean, as a student of public administration and public policy, there has to be a definition in terms of those roles, and there has to be a separation of roles and responsibilities, because a head of department is brought in the department to ensure efficient running and efficiencies in terms of the responsibilities and continuity from a point of view of government. So the administration becomes the what is stable in terms of continuity of government, because political heads come and go. So in terms of the constitution, already the constitution gives the roles and responsibilities. The broader role of a head of an EA is to focus on constitutional matters as well as strategy matters and policy matters in the department, whilst the administrative matters are the responsibility of the DGs. So my understanding historically why some of the roles of the EA roles were put in legislation in the matter that it was, it's because of the transition at the particular time in 1999, when there was work as part of the transition into the public administration. So the sense is that the system has matured enough now to be able to ensure that we align generally with frameworks in public administration in terms of those roles and responsibilities, whilst it helps us to deal with some of the issues that may be the evidence that we have picked up on some of the cross-cutting issues between the particular roles. So it's really from that context that there has to be a very clear separation in terms of roles and responsibilities. And And again, where it says, for instance, it would say the role of the minister or the role of the EA is on strategy matters and policy matters. It does not mean the minister or the EA is not involved in running the department. So I agree with the minister when he says we must look at that perhaps and see how we fine-tune it a little bit to be able. Because remember, a DG enters into a contract, a performance contract with the minister. A minister enters into a performance contract with the president because the minister reports to the president, the DG reports to the minister. And in terms of that performance contract, the minister has ability to hold the DG or the head of department accountable on implementation of the strategy of the department, on implementation of policy instructions and work that has been instructed to the DG. So the system builds for those particular areas. I think now what it does in terms of these amendments, it's also looking at how then when things do not go according to order, what should happen from a point of the relationship between the minister and the DG. So just from that particular framework, yes, we may share anecdotally some of the experiences that we've had in the system, but from a public administration point of view, that separation is critical. And we think that the time is ripe now, 30 years into democracy, the time is ripe for us to be able to look at those particular issues, but sharpen where we think that there's a need to sharpen on certain aspects of it. We should be able to do so, taking into account the inputs that are coming through. The issue of the powers, I've just answered it broadly. I'm not going to deal with the issues bit by bit. Then there was the issue about ukutya okuphekwe ngubani na. I assume by honorable member akatye emngcwabeni ngoba ukutya kwasemngcwabeni ufika sekuphekiwe. But the minister has addressed the issue, so I will not go through that particular issue because the minister has addressed it. Why should it not start from the beginning? Okay, that has also been addressed. Continuity in governance is very important. And then there's a point that the honorable member raises that the committee wants to be part of the bill. And what I would like to say in that process is that the DPSA wants to support you in that process. So if you want us to come back and take you through the bill, we are happy to do so. It is our job to do so. Yes, it's an omission that we have not mentioned the objects. And if you want us to come back to take you through, as I indicated earlier on, at the bargaining council, we had to take people word by word on the bill, and we provided resources to do that. We are happy to do that because that's how we take seriously this work and how we want to ensure that the work continues, of course, taking into account the input of the members and the areas that may still need some further work. We are happy with that. In terms of secondment and transfers, okay, this is a matter of regulations. Renisha will have to attend to it. And then there was the issue of, I think what the honorable member on the issue of acting for 13 years, perhaps what the acting is when a person is employed on a lower or same position and gets to act. So that one, the regulations cover it widely. We shouldn't have any person acting for more than 12 months in the public service. If it happens, there must be request for approval and there must be motivation that is given. Why? Because sometimes there's nobody else to act and the process of recruitment is taking longer. Or the department is still dealing with organizational structure review and therefore have decided not to appoint in that position until that process has been finalized. But the issue here, I think, is appointing people on contracts. Again, our regulations are very clear, and regulations are part of this legislation. So the amendments that we are doing, it does not mean we are rewriting a new legislation. So in terms of our regulations, again, we are very clear on the issue of people being appointed on contract additional to the establishment. What has happened specifically in the Free State is that these people were appointed additional in the establishment since, I don't know, the previous administrations, and they keep on renewing them on an annual basis because, again, contract appointments are not supposed to be more than a year. If they are more than a year, there must again be a motivation. Sometimes there's a special project that covers 3 years or 4 years. That motivation must be processed and approved accordingly. So this particular case, indeed, I actually received a letter yesterday from the affected employees in respect to this matter. And it is a matter that is in courts currently, and the province did not comply with our regulations on this particular matter because no one should be on contract in government for 13 years. You either, because it shows that the function is needed, therefore it means the province should have reviewed their departmental structure, those departments affected, and ensure that those positions are built in the departmental structure, subject to availability of funding to finance those positions. You may, so there's a lot that's happening there, and we will definitely also send our team, now that the matter has come officially to our attention, we will send the team to go to the province and just look at that particular matter. Then there was slide 13 that talked to disparities. I thought this is the PAMA amendment slide because our slide 13 here was talking about something else, but maybe I've missed something, Renisha. And then the changes on the A list, I think we can bring that information when you present now. You can highlight those changes that were effected by the committee. And also let's take the feedback on the definitions that we must define the hopper. And in terms of the relationship with the PSC, basically the hopper function is a function that the president is delegating to the DG in the presidency, and that's the function. The function is already being done. If there's a challenge between me and my minister, the first person I'm supposed to talk to is to the DG, because obviously maybe I can't talk to my minister about that challenge because we can no longer talk to each other. I hope that never happens, Minister. At least you have my commitment, it will never happen. But generally, it happens with other departments. So the first person is to talk to the DG. Usually what the presidency do, they will look at the matter, and if it requires facilitation, they will bring in a facilitator, and a report will come out of it that's making recommendations. That's the key area in terms of that particular role. It's already happening, it's already in the contract of the DG, in the performance contract of the DG, but the matter has to be delegated directly in terms of the law, which is why it's here in the legislation, because that's a function that should be done by the president. The PSC comes in at a later stage when there's an external investigation that must be done, or when a matter has been referred to the PSC by one of the parties, then they can help. The president may, even if there's a case, ask the PSC to investigate the case. So in as far as the role of the PSC in this matter, there is no conflict really. The other question was on the single public administration, section 16, I think there was an issue around local sphere, and then the other issues the minister, I think, responded to. There was a question, Renisha, about how do we address the perceived abuse of power by admin heads, that would be the heads of department. I think I'll leave the team to answer that one, so that I'm not seen as conflicted in responding to it, as I'm a head of department. There is no provision to deal with executive authority. Okay, minister answered this one as well on the minister's responsibilities, and if they fail on those, the EA's responsibilities, and if they fail on those responsibilities, what happens? I think that's all. Chair, with your permission, I've tried to organize questions the team must focus on. Thank you.
Honourable Minister, if you feel that you are ready to take leave, because I think you have responded on political issues, you are at liberty to do so. But thank you very much for availing yourself. Let me request the team to be brief. We are still going to be having some interface on the principal bill, because I think for us to process this amended bill, we need to go through the principal bill, because by 12 o'clock we need to be receiving CoGTA. Let me hand over to you. We still have one bill to go. Thank you.
Thank you, Chair. Good morning again to Chair, members of the committee, Minister, DG, colleagues. I'm going to try to be brief because I think the second presentation gives a lot more detail in terms of some of the questions. So if I may then please be allowed to then deal with it as we present on the second slide, on the second presentation. Just on the recovery of overpaid remuneration for employees. The provision has been redrafted. Initially, there was a view that we could unilaterally deduct monies from employees' salaries, and we had built-in provisions that say when you do that unilateral deduction, you will ensure that it's a reasonable amount and all of those conditions in place. When it went through the processes before it got to Parliament, one of the views was that you must have employee consent to do that. So when the bill presented itself at the National Assembly, the provision that sits in the bill is that when an employee is overpaid remuneration, the employer, being the department, can recover that amount on the consent of the employee. So you can't make deductions of people's salaries without their consent. That's principle number one, and that's in the bill itself. When it went to the National Assembly, one of the things that was changed in the bill, and that was the one of the two changes that was made, was that the bill must include parameters even when employees consent. So the feeling and the sentiment was that some people might not understand what they're consenting to. So the bill then protects employees to the extent that at the end of the month, they still get a salary by which they can live by, but they're still making good on the debt to the department. So the provision itself is now wholly aligned with the basic conditions of employment, and it's wholly aligned with ensuring that there's no abuse on employees. Then DG, the second one I want to address is on secondments and transfers. When it comes to the Public Service Act, transfers are provided for, and it requires that there must be consultations with employees before transfers can happen, and that those transfers can either be by consent or without, but when it's without, it must be justifiable and within the public interest. Secondments, I think DG will deal with when we get to the presentation on the next one. Chair, just on the other engagements, I think DG and Minister have covered them quite substantially. A lot of the issues that have been raised are not primarily coming out of the bills themselves, because the Act is very broad in nature. A lot of the issues are already dealt with in many of the subordinate legislation, like the regulations, the determinations, the directives. So we have really looked at temporary employment, even in last year when we amended the Public Service Act, where we put in very strict controls on how employers may employ people on contract on short-term basis, because the LRA was amended to prevent exactly that. So when the LRA amendments came in, we then went back and strengthened last year our regulations on that. So we shouldn't really, as DG said, have extended and protracted. On the issues of political office bearers and the limitations on that, I think it's important to note that we identified certain issues that needed the law to take care of, so political office being one of them, and looking at the political administrative interface. But there may be many others, like trade unions, et cetera, which we may want to consider either while we do these amendments or for further interrogation by the DPSA to develop policy around that. Because I think it's important to recognize that the LRA already has some limits on trade union activism and trade union relations in the departments. So we might be cautious on how we then go and research and refine to come back to Parliament with a proposal on that. With that, Chair, I want to stop there and then maybe take the next presentation that might address some other queries. Thanks.
Thank you. Yes, you can do that. If there are remaining or outstanding responses, you'll give them in responding to the next one. Thank you. Over to you, DG.
Thank you, Chair. Renisha is going to take us through the second presentation. I think the one other thing I wanted to highlight is that We submitted our documents within the timeframes that are required in Parliament. We submitted on the 3rd of October to the committee. Renisha, you can just take the committee through quickly. Thank you.
Thank you, DG. Thank you, Chair. So in terms of the Public Administration Management Amendment Bill, we ran these two processes, the two bills concurrently. So all of the processes and the timelines are the same when it comes to how we consulted and how we moved with the process. In terms of, maybe a slide before that, Amo. So in terms of what we sought to achieve, and I think this is a broad slide on what we sought to achieve with especially the Public Administration Management Act. I think what's important for members to note is that the Public Service Act it's limited in scope to the public service, which is national and provincial government. The Public Administration Management Act, as it stands, which was enacted in 2014, is the piece of legislation that deals with all three spheres of government. So it's the act that DPSA and the minister administers for the public service, national and provincial government, as well as local government. So when we talk in the context of this bill, we talk about a single cohesive government across the three spheres of government. And we take our thread of marching orders from the National Development Plan, the labor legislation, all of the policy that has changed, including the Zondo report, the professionalization. So you will see throughout these two bills, that is the thread. It's common across it, but you will find elements of all of these things and responses to these. When we did the Public Administration Management Amendment, we looked at how we utilize what exists already in terms of law, because we don't want to rewrite all the laws. You have the Municipal Systems Act, you have the Municipal Structures Act, you have the Public Service Act. They all regulate different aspects across the administration. So the view and the context within which we looked at the bill was to see what was missing between all of the laws that we could regulate centrally into this bill, but also to look at the administration holistically so that we are synergized in what we're doing. So when national government is doing 1, 2, 3, local government mustn't be doing 4, 5, 6 and then become disjunctured. There must be some thread that runs between the administration to ensure that, one, the state has capacity across government, and that the state has the capability to deliver on services. So capacity, we're looking at people, capability, we're looking at systems, processes, and so forth. So that was what we sought on a very high level to achieve with the Public Administration Management Act. As I said, the processes were the same in terms of what has happened. In terms of the content, and I'm going to try to be brief, noting the time, Chair. The Public Administration Management Act then sought to deal with very specific areas, and I've talked to them, and I'll talk to them in the slides that we go on to. In terms of Clause 1 on the definition, on the initial act itself, there were problems in implementing the act. So a lot of the amendments are also to deal with some of the problems and challenges we had. For example, we didn't have key definitions of head of institution, Labor Relations Act, Municipal Systems Act. So we've included many definitions in there so that when you interpret the act, it becomes a bit easier for people who are not lawyers, who want to just understand what the law is. So we are also trying to put in definitions that will assist. In terms of individual transfers, the provisions are initially proposed in the bill, and I've spoken to this. Initially, the bill sought to deal with transfers across the public administration. So the Public Service Act deals with transfers between national and provincial departments, whether between the spheres, between the departments themselves, but there is a provision under Section 14. In 2014, when the PAMA was enacted, it repealed Section 14 of the Public Service Act. Through these amendments, we are reenacting Section 14 of the Public Service Act to retain transfers as it is currently, but also to deal with the vacuum that exists where persons employed within national and provincial government can't be transferred to local government or municipalities, or where you can't transfer employees between municipalities. And transfers has a connotation of ensuring that you don't lose your benefits. So what we've done in this law, we've enabled transfers. How employees and employers use the provisions of transfers is set out in the bill. One of the fundamentals of transfers, noting that people that move between municipalities and move from the public service to a municipality or from a municipality to public service, have changes in conditions of service. And it affects them, and it might affect them. And what we have done in the bill is we've said, if you are transferred, it must be one with consent. If you are transferred, it must be without any loss to you. So we've put in safeguards in terms of creating the enabler to transfer. In terms of secondments, and I think this then addresses one of the questions that was asked, is that we have strengthened, clause 3 of this amendment bill amends section 6. And if you see section 6 in the current act itself, it enables secondments. What we have done is we have aligned it to how we have done transfers, to the extent that we say transfers and secondments must be operationally justified. You can't have transfers and secondments that take place that are not operationally justified. So we have just added in the words operationally justified. And I think just in terms of, there was one question, and I want to address it here also, is that when we talk about secondments to institutions, secondments are temporary in nature. They are not intended to be full-time employment in another institution. If you want to make it a long-term secondment, people must utilize the transfer provision. That's what it is. You can't be saying, I'm seconding Renisha to wherever for 4 years, because when Renisha leaves, wherever she is, somebody takes on that volume of work. So you must ensure that there's no abuse in the system when transfers happen and secondments happen. Then in terms of clause 4, and this deals with transfers of functions. Transfers of functions are already dealt with both in the Constitution as well as the Public Service Act and other legislation. So it became not possible to implement Section 7 of the current Act, and we are therefore proposing that that needs to be repealed. In terms of clause 5, which deals with prohibition on conducting business with the state, what we have done here is we've made some additions and some amendments that deal with issues where the provision has become difficult to implement. So we currently have this provision. We currently say no public servant is allowed to do business with the state, nor is that public servant allowed to be a director of a company that does business with the state. And that in itself was designed to ensure that there wasn't a conflict of interest. You didn't use your positions within government to enrich yourself outside of government. What we have done in this amendment is we are keeping the principle of the statute, but we are dealing with situations where currently the Act says state, and people don't understand whether state means organ of state or state means something different. There is no definition. So we've put in a definition of organ of state, and we've clarified the definition of organ of state and the reference in the oh. Then in terms of, we've aligned the provisions, we've defined what a director means, we've aligned the definition with the Companies Act. We've also, Chair, dealt with a situation where the provision itself has created unintended consequences. For example, there are departments who, as a matter of other statutes, have representatives from those departments into companies that are SOEs. And those SOEs, by their ordinary function, do business with the state. And what we are saying is that we are excluding those employees from the prohibition of doing business with the state, simply because if you contravene this provision, you are then subjected to criminal prosecution. So the statute in terms of ex officio board members is then covered and clarified so that we don't have employees who fall foul to this provision, and therefore you can't perform functions that you should be doing by virtue of your office in a department. The second one is to clarify and to allow the minister, because the list of people who can be construed within this provision sometimes becomes changes due to circumstances. So what we've allowed is for the minister to prescribe through regulations those other institutions or those other officials holding office who should not be construed as part of these limitations. Another example is teachers who mark exam papers. They get paid by the state, but if you read the definition, it seems to ascribe to them then falling foul to doing business with the state because they get paid separately outside of their remuneration. So it's for those instances where we are saying the minister can then set up a list and prescribe through regulations those occupations and those things that are not construed within the provision. Then in terms of conducting the conduct of employees and former employees participating in the award of service providers. This is a new provision that is not regulated in any other piece of law. What we try to do here is to prohibit, and this comes straight out of all the lessons learned by both the Zondo Commission, talking about professionalization, dealing with our procurement issues, is what we are prohibiting is that employees who are part of any procurement process, whether you are adjudicating, evaluating, setting criteria, approving the procurement, you are prohibited from joining that service provider from which you have participated in that process. And the cooling off period is 12 months. We have limited it to 12 months simply because it's a restraint of trade, and we have to justify in terms of the Constitution any limitation on constitutional rights. We have looked into the matter, and the determination was that 12 months is a sufficient period to allow that employees can't join those service providers. And we've also placed the obligation on service providers themselves. So service providers themselves also cannot employ persons who have been part of those processes where those service providers have benefited. We've provided for a fine to be imposed on people who are found to have committed the offense of contravening that provision. In terms of Clause 7, we deal with financial interest and the disclosure thereof. Here, it's not a major amendment. We've inserted a provision in it for the clear drafting. Previously, there was a provision that said Section 8 and 9 also extends to special advisors and those persons providing special advisory services in municipalities. But it was put in one of the provisions, and reading became hard, so we've put it into the second one as well. So it's just a drafting. In terms of the capacity development and the National School of Government, and Chair, here I'm going to quickly just combine clauses 8, 9, 10, and 11, and 12, simply to, up to 11, just to deal with the National School of Government and to tell the committee what we are fixing in these processes. So the National School of Government, under the Parma Act itself in 2014, establishes the National School of Government, which we know to be a department, as an institute of higher education, which means it needs to be redesigned, reorganized, and taken out as a department and reestablished as an institution of higher education. The difficulty with that is that you create another higher education institution that might not necessarily focus on what the public service needs are, or the public administration needs are. So what we are proposing is that the National School of Government retains its current stature as a national department, but we have also provided for additional responsibilities so that the National School of Government can, one, partner with higher education institutions in doing its and rendering its services. The the National School of Government can also, through provide programs, provide the training, provide the qualifications, etc., designed again specifically to address public service and public administration needs. So, Chair, the proposal is that even when it comes to local government as well as SOEs, these institutions can also then request the NSG to provide specific training for purposes of those SOEs and municipalities. So in broad strokes, that is the provision we are amending, and the consequent amendments are then the ones that you find in the subsequent clauses. One addition on clause 11 is that we are saying that we are amending section 13 of the current act. Section 13 requires that when the minister determines mandatory education and training, that he or she needs to also then have cabinet concurrence, and we have removed the requirement to get cabinet concurrence because it just places an unnecessary burden on cabinet to look at the training and development. Then in terms of section 12, minimum norms and standards, this is a little bit complicated in terms of, and I hope I explain it properly, but we are repealing section 16.2 of the Public Administration Management Act. In section 16.1 of the Public Administration Management Act, it states that the minister may issue norms and standards on a number of issues that are listed in 16.1. But 16.1A says if the minister is issuing norms and standards on the promotion of values and principles contemplated in section 195, the minister needs to consult all EAs. And EAs means your municipal councils and your and all of your departmental ministers, which makes the implementation of this particular provision difficult, because if one MEC or one minister or one municipal council for that matter doesn't agree with that particular norm and standard, then the implementation thereof falls away. So we have then removed that provision to ensure that whatever regulations the minister does is then similarly done in terms of the provisions that are already provided for to make regulations. The Office of Standards and Compliance at clause 13 is a small amendment. It's removing the words "and its members" simply because there isn't any provision in the Act itself that defines what is meant by its members. The office is defined in terms of what its functions are and what its roles are, and we have therefore just proposed an amendment. Chair, my last two clauses that are quite important is the insertion of section 17A and B, and I think this is the one that the Honourable Member was talking about when we looked at unjustifiable disparities and how we intend to deal with it. So I'm going to deal with 17A. First starts with the removal of disparities in the administration, and the administration being local government, public service, national and provincial, as well as for purposes of this provision, we have now included your SOEs. So we are saying throughout the public administration in that very big term, we are wanting to remove those disparities that are not justifiable in terms of conditions of service. I think what's important is that, one, we are not trying to undermine any collective bargaining process. Two, we are also not saying everything should be the same across. We are understanding that different institutions will have different needs and different areas of expertise. But what we are saying is where you can't justify the disparity. So you have a DG in Department A and you have a DG in Department B, and you have a municipal manager in a municipality, and they're earning different things and the conditions of service are different. The question we should ask is why? If somebody can explain justifiably why, then it's not an unfair disparity. But if there isn't an explanation, then what we have done in the process is to allow the minister to take steps to remove those unjustifiable disparities. And by doing that, we have provided that the minister may, after consultation with relevant ministers, prescribe norms and standards to set upper limits of remuneration and conditions of service. And this is for employees who are not within bargaining units. So it's your senior management service. So we're looking at your executives in the SOEs, we're looking at your top management in municipalities and your top management in the public service, because those don't get negotiated. And we are saying that there must be some limits that we must place, and that we are placing the obligation on the minister to determine those. And the minister does that through regulations which are publicly consulted. There's a process for these regulations, so there is interaction. And then we are suggesting that the minister may put in place steps to remove these unjustifiable disparities, provided that there isn't a reduction. So the process is to ensure that we protect employees who are in the process, but we ensure going forward that we remove those unjustifiable disparities wherever they exist. The reflections of changes, and I've included this, Chair, for purposes of the committee, is that this was one of the provisions that was changed in the National Assembly during the consultations. Initially, we had intended that all of these provisions apply to all members of, or all employees within the administration. But during these deliberations, there was resistance from Labour, there was discussions with consultations and etc. at the Portfolio Committee. And the provision that ultimately was amended and submitted to this committee is that the provision of 17A cannot apply to all employees. There must be a distinction between employees that have their conditions of service negotiated and those that are in the senior management positions that usually don't. So the provision now, as it stands before the committee, has been limited to affecting only senior management services. Then, Chair, in terms of Section 17B, and this relates to the mandating of conditions of services with financial implications. This simply is a process to ensure that we have a fiscal framework that stays strong. So you would have heard comments about wage bloating, wages taking up more of the money that is left so that service delivery doesn't happen. And the difficulty with the system we have now is that we have a disparate way of determining conditions of service. There is no one central point where conditions of service are looked at a macro level. So when SOEs need to amend and adjust their salaries, they do it in line with their minister in terms of their laws, which necessarily doesn't come back sometimes to the Minister of Finance or the Minister of Public Service, similarly with local government, similarly with the public service. So what we have done here is we have tried within the confines of what we are authorized to do is to at least create a focal point where at least two ministers, being the Minister for Public Service and Administration and the Minister of Finance, will have oversight over what is going on across the administration, including SOEs, to determine whether what is happening is fair, not fair, transparent, etc. In terms of the Public Service Act, there are provisions that there's a committee of ministers who give a mandate to the negotiators at the PSCBC to determine conditions of service for public servants at national and provincial department. That process we are proposing stays, where no employer can do that without going to the committee and getting that mandate. Initially in the bill, we had provided that that committee of ministers must similarly then have that kind of powers over SOEs as well as municipalities. During the consultations and the deliberations of the portfolio committee ultimately amended the bill to say that the committee of ministers can exercise veto powers in terms of the public service to the extent of to the extent of national and provincial departments. It can determine and mandate those processes, but it should not have veto powers over SOEs and local government. So ultimately, the bill was changed to say that for local government and SOEs, at the very least, the Minister for Public Service and Administration and the Minister of Finance must be consulted. Doesn't mean they have to agree, but they must be consulted. What we have also reflected on as contained in the bill is that there is a provision for the Minister and the Minister of Finance to determine factors that should be taken into account, at least at a very minimum level, the things that should be factored and consulted and considered when any employer changes conditions of service. So affordability and those matters will be set out in regulations, but the provision is to enable at least that process so that all institutions, wherever you are, will follow those particular factors. Then in terms of clause 15, and I'm getting to the end, Chair, this is an amendment to amend section 18. Currently, when the minister makes regulations under the Public Administration Management Act, there has to be concurrence and agreement between the Minister of Finance, the Minister for Public Service and Administration, the Minister of CoGTA, as well as SALGA. What we have done and what we are proposing and has been adopted by the Portfolio Committee is that we are aligning to what currently exists in the Municipal Systems Act, where we are saying we agree that the Minister of Finance, the Minister of CoGTA, and the Minister of Public Service and Administration must agree on any regulations that occur under this Act, but it must be done after consulting SALGA. So we are no longer requiring SALGA to consent, but we are requiring SALGA to be at the very least consulted. Then in terms of any regulations that affect public entities, we have provided in the bill that they should be made after consultation with the minister responsible for public entities. Perhaps, Chair, that might be something we look at, considering that we no longer have a minister responsible for public entities. As one minister, we have them in the various ministers, so we might have to consider amending that provision. And then in terms of clauses 16 and 17, Chair, 16 just requires a little bit of explanation. In the original PAMA, in the PAMA Act as it stands, it repeals section 14 and 15. What we are proposing is that section 14 not be repealed, so we are reenacting section 14 of the Public Service Act. And we are also then making an amendment in terms of section 22A of the Public Service Act, because we have amended the provisions that deal with the Committee of Ministers, the Mandate Committee. We have to go and fix how it's written in the Public Service Act, so it's a consequent amendment. And then the short title and the commencement, again, is similar to what is in the Public Service Amendment Bill, which is by proclamation by the President. Thank you, Chair.
Thank you. We welcome the presentation, the additional presentation. Colleagues, I want to put this suggestion to you, that having learned from the first presentation and the engagements we have held, there was an indication that there is a dire need for principal bills to be presented before this committee, so that when we engage on the amendments, you engage from the informed point of view, rather than dealing with amendments at this fashion. So if that is agreed, I'll request that you observe your right of asking questions and clarities is fine, but we move it, we defer it to the engagement which will held. And we'll have to organize that within our schedule before the end of this year. To request the department, the PSA, to come and present these bills at DG and to all of us. Is that agreed? Thank you. Thank you. That brings us to an end of the engagement with the PSA. We wish to thank you, DG and Honorable Minister and the entire team for having taken your time to come before this committee, and we'll continue to engage with you on a number of issues. We are still finalizing our oversight plan, which will conclude and will give an indication how we'll interface with you. But thank you very much for everything and the levels of preparedness before you arrive to us. Thank you for that. Let's give them a big round of applause. Thank you. You can take leave. We remain with the legislature representatives for the next bill on demarcation board authority. Yes, thank you. Can we call the next department to come in? For a comfort break, individual members will go out whilst we proceed. No apologies now. All right. In the meantime, let me request our legal team to outline the processes on how do we envisage to process these bills, and what is expected of all of us from the provinces and at the NCOP level. The team will just outline those processes. You ask questions if there are questions. Over to you, ma'am.
Thank you, Honourable Chairperson. Thank you, Honourable Members. Good afternoon. I'm going to be as brief as possible, but during, while DPSA was presenting, Chairperson just asked me to set out briefly what is the process in terms of processing a Section 76 bill in this committee and what is expected from members and from us. I'm Talana Halley-Starkey. I am a legal advisor at the Constitutional Services and Legal Services and Constitutional Office. It's a mouthful. I will set out the procedure as follows. So, in terms of a Section 76 bill, which is a bill affecting provinces, this committee will then, and I'd like to draw the committee's attention to National Council of Provinces Rule 176, 177, and 180. So if members aren't familiar, you could look at those rules. It sets out what is expected. The procedural advisor can also provide clarity as to what the procedure is, but I'd like to state from the onset that each committee is different. The committee is reminded of Rule 176, which states that each committee may arrange its own business when it comes to public participation. And here I'd like to pause, and it's important to understand that in the past, Parliament has been left wanting when it comes to public participation, and public hearings, oral submissions, and written submissions. However, it is up to the committee to decide on what type of public participation that will look like. So, at the beginning, once you've heard the presentation from DPSA, the bill will then be advertised, and a call for public comments will then ensue. Those will be written comments, but the committee is then, it's up to the committee to decide whether they would like oral submissions or whether they would have like public hearings. Now, the Provincial Legislature has its own obligation for public hearings, but if the committee also sees it fit that they would like to do their own public hearings, it is reminded of Limosa, where the court said that public hearings should take place in provinces, but these hearings are also part of the National Council of Provinces process. Notwithstanding the fact that provincial legislatures have their own distinct obligation to facilitate public participation, this is not separate. It's not a mere appendage of the National Council of Provinces. So it's not a mere appendage of the National Council of Provinces, it is separate. So if there are any shortcomings in the provincial legislature regarding public participation, this will also affect the National Council of Provinces. And then I'd also like to remind the Committee of Doctors for Life, which basically states when you look at public participation, you've got to look at the nature and the importance of the bill and the right that it affects, the time before Parliament, how much time does Parliament have, or how much time does this committee have to process the bill. There is no constitutional court deadline for this bill to be processed, and also the rules of Parliament, and that we look at the public participation model, which looks at feedback, provide involvement, provide consultation, and then inform. And also bear in mind that you have to provide a reasonable opportunity for public involvement. That said, I stopped at the part where this bill will be advertised, we will receive comments, and this being the first step, once the advertisement goes out, the committee can then decide on what type of representations they will have. The committee will then also decide on what is the program moving forward. So, we will receive comments, the members will then deliberate on the bill, they'll ask questions, legal services will have an opportunity to respond to those questions, the department will have an opportunity to respond to those questions, members will then also ask clarity-seeking questions from submitters, and then that's where the nuts and bolts of the legislating process comes into play. The committee will then look at the bill and see, okay, well, you know, we got all these submissions at this stage, let's possibly do more amendments. And with that, then I would like to draw the committee's attention to Rule 180, the National Council of Provinces rule, which basically states that if there are any changes, 181B, made in this committee, it does then not get assented to the President, it will go back to the National Assembly. So that's what the committee must also bear in mind if they do want to make any changes in this committee. And I've just set it out, and then following all the public participation and all the deliberations, we'll then have negotiating mandates where each of the permanent delegates will bring their negotiating mandates. And if there are questions from the provinces, once again, legal services and the DPSA will respond to each question on the negotiating mandates. I think I haven't left anything out. If there are any questions for clarity, I know I was speaking really fast, but I know the committee is pressed for time. Thank you.
Thank you, Ms. Doki, for your presentation and to outline all the processes that needs to unfold. Members, any clarities, questions? So with this one, we've got no pressure. The only one that we are pressurized in terms of timelines is the one that is coming. Honorable Badenhorst?
So I just want to ask legal services, is there a specific timeline for public participation in our rules of the NCOP? So it's a minimum period?
So there isn't a specific timeline, but normally we do 14 days. And that's a very good question, Honorable Banus. We have been also found wanting when advertising during the December period. So I would caution the committee not to advertise during the December period. And yeah, we usually do 14 days for advertising.
You covered, Honorable Badenhorst?
Yeah, that's the advertising, but the actual process of public participation, is there a time limit to that?
There isn't a timeline, and as I said, the courts have given us guidelines to what public participation looks like. there aren't any rules per se for public participation, that besides the constitution itself.
Thank you. Any further questions? Are we all covered?
Okay.
Oh, yes, my provincial chair.
Thank you so
Honourable
much,
Nair.
Chairperson. So I just need some clarity, Chairperson. I understand that this bill has been deferred from the 7th Parliament and that quite a few provinces conferred their negotiating mandate. So I just want to see, are we going back and starting from scratch? Where are we in the process, or are we just continuing? So perhaps some clarity on that. Thanks.
Thank you. Any further clarities? Okay, let's get a response.
So as you know, Chairperson, this bill was then sent from the previous Parliament into this Parliament. Even if there have been negotiating mandates sent, I don't think that all the negotiating mandates have been sent yet. And I think if there have been public participation in the previous Parliament, nothing prevents this committee from doing public participation again. In fact, I would encourage it. There has been considerable time lapsed, but it's entirely up to the committee to decide what that program looks like. Once again, I'd like to remind the committee of NCOP Rule 176, where it states that the committee has its own prerogative to deal with its business. So it's entirely up to the committee to set its program.
You can come in. Yes, Honourable Kaiser, Honourable Bedenost and Manele.
I remember this bill, Chair. I was serving in the NA on cooperative governance, traditional. We debated this bill. And therefore, I want to get an understanding, because I'm new in the NCOP. What is the process? Because we dealt with this bill in the National Assembly, if we are talking about the independent municipal authority bill. And we went for public hearings. And subsequent to that, we came back and then we debated the bill and we pointed out as to what are the gaps and so forth, and then we laid out our position on it. And in terms of the concurrence process, where are we at? Because we dealt with the bill. I'm just seek clarity on that. Thank you.
Thank you. Honourable Bedenost.
Yeah, thank you. That's basically now what I was going to bring up after the briefing, because I understood on the notice of this meeting, the agenda, that we'll get a briefing on the department's response on the negotiating mandates received from provinces. So my understanding is we're not going to discuss the clauses of the bill today. We're going to look at the negotiating mandates. So that brings me to my point. And I was in the 6th Parliament in the NCOP. And I was in the CoGTA Select Committee. Yeah. And I think I'm the only one sitting on this side of the bench that was in that committee in the 6th Parliament. And so I want to bring to your attention, Chair, that there was a slew of bills that were presented to us at the end of the 6th Parliament. They were coming thick and fast, and this was one of them. I've got in my hands here a letter that was written by the then Speaker of the Western Cape Provincial Parliament to the then Honourable Masondu, the Chairperson of the NCOP, and that might give some background, if you will allow me to read this letter. Pardon? The demarcation, the independent municipal demarcation bill. Sorry, I understood we're talking about that bill now. Are we on the previous bill?
Yeah, sorry, if I can provide some clarity. I am only referring to the PSA and the PAMA.
Okay.
So that's why I'm a bit confused. The PSA and the PAMA have not been dealt with in this committee. We've dealt with it, you are correct, in the National Assembly, but not in the National Council of Provinces.
Apologies, I'm one step ahead of you.
That's okay.
You want to catch your flight? Okay, Mr. Manele, you can come in.
I just want to add on, with regard to these two pieces of legislation before us. During the sixth administration, this committee, these legislations were referred to the select committee, the one that is now public, the one select committee on infrastructure. But taking into account that CoGTA, during this seventh administration, it has added responsibility, public service and administration. These bills, in terms of referral, they are now before the select committee chairperson. But in terms of the record of that select committee during the sixth administration, there was no process yet with regard to the consideration of those pieces of legislation. What we are doing today as select committee on CoGTA, it's our first process to consider this piece of legislation. I just wanted to give that information to members so that they can make a decision on that. Thank you.
100%. I was a bit confused with regards to negotiating mandates because I was informed that we haven't received any yet. Okay, thank you.
Okay, I think it's all clear now, members. Then we are going to release you as you have requested. Who's remaining behind? The legal mandate is remaining behind.
I don't know who's.
So-
This bill is not my bill. This next bill.
Yeah, even if it's not your bill, it's fine, you'll advise. All right, let's then welcome the team from CoGTA, which is led by Dr. Naidu, and the entire team. You are welcome to this select committee. We are ready for you to give us a presentation on the bill, and we'll engage. We are constituted by permanent delegate of NCOP. We also have special delegates, the chairs from provinces, from provincial legislatures, who are part of us. So you are now going to be given at least 30 minutes to present, and the other 30 minutes is for clarities, then we close. 1 o'clock we are leaving this room, so we'll finish early, members. I'm making that commitment. Okay, Dr. Naidu and the team, you can take us through. Thank you.
Good afternoon, Honorable Chairperson, and all honorable members of the committee. I am Kevin Naidu. I'm the DDG responsible for policy, governance, and administration in the Department of Cooperative Governance. I'm joined by my team, Honorable Chair, Mr. Elferson Doe, who's the Chief Director, Mr. Nhlamulo Mate, who will be making the presentation for us. Mr. Mate. Mr. Sonwabile Nkaichana, he's the legal drafter in the department. We're also joined by Mr. Manye Moroka, who's the CEO of the Municipal Demarcation Board. Honorable Chair, we have... We have put together a presentation, quite a lengthy one though. We will try and stick to the 30 minutes. The presentation references the background as to how we've arrived at the bill. It deals with some of the, well, it deals with the provisions that's in the bill. We will focus on some of the key issues that is in the bill. We will also deal
Sorry,
with
Dr. Naidu, could you please hold? Honorable Badenhorst.
My sincere apologies for interrupting, Dr. Naidu. I just want to clarify, Honorable Chair, the agenda for this meeting clearly states that we will be dealing with the department's response to negotiating mandates received in terms of this bill in the sixth parliament. It doesn't state that we're going to be dealing with the
the bill clause by clause in this meeting. Thank you.
Is that how we have prepared as well? Because that was our directive, Dr. Naidu?
Indeed, Chair.
Okay.
We did feel that this being a new committee, that maybe it would have been of benefit to go through the provisions, but if that is not required, we can go directly to the negotiating mandates, which is in the presentation as well. So
Yeah, no, you can deal with the objects, then just the summary of that part, then you deal with the responses. Thank you.
we thank
The
you
chair
very-
has made a ruling.
Thank you very much, Honorable Chairperson. I'm going to hand over to my colleague Nhlamulo, who will take us through the presentation.
Good afternoon, Chairperson and the members of the committee, as well as any other designated officials that are present in this meeting. As directed, I will take you through the presentation. This is how the presentation is structured, but given that we'll just provide the broader overview of what the bill entails before we can deal categorically with the clause by clause. With the responses to the negotiating mandates. This slide just shows the genesis of how the bill was born out from, which I may not take time on those. This also is a process plan in terms of how we've dealt with the bill post its approval by the cabinet for publication in the Gazette for comments, up to a point where it was introduced to Parliament, and based on the rules of the National Assembly, the bill was also introduced to the National Assembly, and there was some public consultations that were taken by the Portfolio Committee in the National Assembly, and the bill was referred to this House for further processing. And we have closely worked with provincial legislatures in terms of dealing with the conducting of public hearings on the bill, and we have supported them also in the during public hearings. And this is where we are. That's where the bill has lapsed in the 6th administration. But just to provide a broader overview of how the bill is configured, this is how it's configured. Chapter 1 deals with those definitions that are assigned inside the bill. And Chapter 2 deals with the operation and administrative matters of the board, which include the establishment, the status and powers and functions of the board, and how it deals with various matters relating to staff and finances. Chapter 3 deals with the main mandates of the board, which is the determination and redetermination of municipal boundaries. It also establishes the Demarcations Appeals Authority, which we didn't have before. So this bill introduces the DAA. That appeals committee will deal with the disputes arising from the demarcation-related matters. It also provides for the board to conduct mandatory capacity assessment at least once in a cycle, in a term of local government. And then Chapter 5 deal with miscellaneous issues. Those are the regulations and guidelines, offenses, and the amendment and repeal of certain provisions, as well as the transitional arrangement measures. So, as directed, I will not deal much, but just to indicate the long title as directed, that the bill deals with the establishment, provide for establishment of the Independent Municipal Demarcation Authority Bill, Authority Bill. This maybe just to indicate in the upfront that this specific bill amends and replaces, seeks to amend and replace the Local Government Municipal Demarcation Act because through the magnitude of provisions that were brought into this specific bill, it was felt necessary that this bill be introduced as a new bill and replaces the Demarcations Act as it is now. And that as well, because the Constitution provide for the establishment of independent authority, we felt it necessary that that should be also aligned to the founding provision in the Constitution, hence it is now called the Independent Municipal Demarcation Authority Bill. Let me rush straight now to the various responses that we have received. I'm not sure that I thought this was also critical a bit, because these are the comments that came out from the Portfolio Committee in the National Assembly as it relates to the bill. These are the proposed changes that the committee has proposed that were incorporated into the bill. This slide just depicts
You can go through them from the portfolio, because it's important that the select committee knows what was the feeling of the portfolio committee in the NA. You can go through that.
Okay. What has been included, the bill that we have produced was reflecting to the members of the persons to be eligible to be part of the board, to reflect broadly, and the committee changed that to say it broadly reflect. But the main bone of contention here was that because there was some misinterpretation and understanding in terms of how the members that must form part of the board must be constituted. Others would construe it to be members proportionally coming from different provinces and appointed into the board, but that was not the whole intention of the Act. But just to clarify that it should broadly reflect the South African society, meaning it doesn't have to be proportionally one person in each province appointed into the board. So in clause 9, they just inserted that a need for a relevant qualification. So it was just qualifying the qualifications of a person to become a member of the board. In clause 16, the board, this bill empowers the board to also appoint a committee. So they were saying that perhaps the same qualifications or areas of expertise as provided for in 9.2 must also apply to these specific individuals that are appointed to be part of those committees, and that their names must also be published in the website of the authority. And they also inserted, they removed the integrated development from the objectives of municipal demarcation boundary process. They also inserted in the provisions that deals with the public participation in the demarcation process, the relevant provisions that deal in the Systems Act that deals with broadly much more about the component of public mechanism for public participation in the demarcation process. So extended also the period within which the Minister of Finance may be informed in terms of the demarcation outcome of the board, which is now is extended from 6 to 9 as initially proposed. And also the clause that I think this was to promote oversight from the committee side, that any regulations that the minister promulgate must also be bounced with Parliament for further scrutiny before they can be promulgated into law. So those are basically the issues that were inserted from the Portfolio Committee. This slide just depicts how we have gone through provincial legislatures briefing, where we have supported each of those provincial legislatures on those specific dates supplied in that specific slide. So in terms of the negotiating mandates,
Only indicate Eastern Cape issue before they even ask the question.
Upfront, yeah. Yeah, just to indicate upfront that no, thanks, Chairperson. The issue around Eastern Cape, we did conduct the first round of briefings immediately after the bill was referred to provincial legislatures. But what happened at the time, 7 provinces submitted comments, with the exception of Limpopo and Eastern Cape at the time. Then the chairperson then extended the period again to say, submit this negotiating mandate, but Limpopo complied, but Eastern Cape did not provide the committee as at the end of that 6 administration. So it's only 1 province that did not provide.
Okay, yeah, no, they requested the further extension, that the time was inadequate for them to process this as expected. So therefore, you are left with 1 province out of all the 9 provinces. So there's a province that is still remaining behind. So we have up to December this year to finalize these processes. So the committee later, after a presentation, will have to make a determination whether we allow Eastern Cape to proceed with its consultations, and we also respond if there are provinces which will say, no, if you open for Eastern Cape, even our process was not adequately covered, we'll wish to go further and consult. So I think we'll have to look at those matters that will be before us. But procedurally, this process coming from the 6th administration must be concluded by December 2024. So we'll have to make such a determination whether we start afresh or we proceed with the process. So you'll give us an indication on the agency of this and whilst we discuss. But you can proceed with your presentation. I interrupted you.
No, thanks.
You can proceed.
Thanks, Chairperson. I think that was critical indeed. So in terms of the responses that we have received, we did receive responses from the Northern Cape, but these that came from Northern Cape was mainly about demarcations per se, not necessarily about the bill itself, but the outcry was much more into community participation, which this bill specifically provide much more avenues or maximizing more in terms of enhancing public participation in the demarcation process. So the other issue that came, now it's Northwest. Northwest provided their input in relation to the criteria that is used for a demarcation process, and they were indicating that we need to consider the access by communities in terms of wards and the impact of such. So we're saying this is not supported on the basis that the bill itself provide for various factors to be taken into consideration when municipal boundaries are finalized, and these include the functional service delivery boundaries, magisterial boundaries, and service delivery boundaries aligned to health and other related services. So the other comment came out from the KZN. So in relation to those that came into KZN, they were saying perhaps we need to include in the notice that the minister publishes after the appointment of board members, also include their relevant specific qualifications that those individuals possesses for both committee that the board establishes as well as the board members themselves. So we accepted that, we support that proposal because it also provides for a transparent process in terms of members that are appointed into that critical board. The other issue that they've raised is the issue around the filling of vacancies. They're saying that that need to be reviewed, and as well the way it is, it must be subjected to time frame in terms of those specific appointments. So we're saying that this is not supported on the basis that the bill already provides for a provision for a minister to initiate the relevant appointment process, and including filling of those vacancies through, of course, recommendation to the President for filling of those vacancies that may arise during the term. So there's an issue of establishment of appeals committee, and the proposal that came out is that we need to have a more comprehensive process in Clause 38 that deals with this appointment of the Demarcation Appeals Authority, similar to that of appointment of the board. So we did not support this on the basis that there should be, of course, a need for a clear delineation or identity in terms of how the two processes unfold. So there's responsibilities of the board. They were saying that we need to add that the board act independently at all time, exercises judgment and all that, but we could not support this on the basis that the status of the board as a juristic person is clarified in the Act and in the bill itself, as it says that the authority must be independent and performs its function in a manner that without any fear, favor, or prejudice. So with that statement, the independence of the board is not questionable in terms of how they need to perform their functions. In the committees, they are saying we need to also, the criteria and the qualification for the co-opted members are not specified, so we need to put those specific criteria and the qualifications. So hence that is supported, and we are saying that the same process should apply as set out in the 9.2 dealing with the qualifications for board members. The committees as well, they're saying we should provide for the number of limitation, place a limitation in terms of the number of members that can be co-opted. So we're saying that can be dealt with within the internal rules and procedures of the Demarcation Board in terms of how it manages its affairs. 26 key considerations must be given to 5-year term, and the time frame for considering the determination of they are saying the 10-year that is being proposed or put forward for major redetermination, it might cause administrative issue, and we're saying that is noted, but what is has been mainly proposed there was to ensure that there's a long-term planning, hence we introduce the 10-year cycle of major redetermination of municipal boundaries. The qualifications of appeal authority, this one is similar to the previous one, which is not supported for the same reason that I've advanced earlier. And now this specific comment here from Gauteng was to say that they recommend that the 3-year budget is provided for transitional measures where the board would have redetermined a municipality. So we're saying that is already the practice that the National Treasury provide from the national fiscus the amount to support those transitional arrangement measures. Clause 26, here there is also that issue of the 10-year cycle. So they are saying the 10-year cycle should also apply to what delimitation process. So this is not supported for on the basis that there are a lot of practices that happens at the ward level, changing in migration of population within that 5-year period. So we're saying let the board continue with the ward delimitation process and can also consider the major redeterminations where it affects more than one ward over a period of 10 years. So municipal capacity assessment, here they're saying this bill does not go far in terms of ensuring that capacity assessment is defined. So this is noted, but definitely we will not have pulled everything in terms of how the capacity assessment must be conducted, but given that the bill itself also provide for the minister to prescribe any matters that are incidental there to facilitate the implementation thereof, can also deal with those indicators in terms and the criteria in terms of how capacity assessment may be conducted through the regulations. This is just a general matter for noting, and part of those generals was to include the traditional royal house. So we're saying the bill goes is sufficient in terms of the consultation of traditional and Khoisan leadership at all levels, from the local, provincial, and national house, the way it's designed now in this specific bill. So Pumulanga also provided some comments, and part of the comments as well was the inclusion of traditional leadership. We're saying we have tried by all means in the bill to ensure that they are also consulted and involved in various levels. And there's also about the establishment of appeals authority. They are saying that there should be some time prescribed in terms of handling of each of those cases, which is already covered in the bill in section 43 of the bill. The appointment of board members still in Mpumalanga, they are saying now that we are including the chairperson of this committee to be part of the panelist towards the appointment of the board members. Saying that might also bring about compromise the independency in terms of those appointments. So we're saying this goes far beyond because the selection panel also include the judges, the Chief Justice, and other designated officials. So which we may not have those practice having to occur. The ensuing other clause as well is much more similar corresponding comment. The finances of the board, they're saying the bill indicate by stating how the board will address the unique challenge of lack of resources, which often hampers the board. So we're saying the board will continue to receive the money through the appropriation, through the, of course, subject to the conditions of the National Revenue Fund, because we may not want the board to be compromised through certain sources. General Khoisan, inclusion of Khoisan, which I dealt with already. So from Free State, these are the comments as well. They're saying we should also include the percentage in terms of those people living with disability to be also be included as part of for those appointments. So we're saying that this is something that can be considered by the selection panel through the appointment process.
Please, in all documents, remove that living with disability. Just say people with disability.
Not
yeah, otherwise, if you have you attended the summit with the sector, once they see that, they even rise physically to fix you at the same time. So need to be careful on the documents.
Noted, Chairperson. So they also commented on clause 10 that perhaps in terms of how the nominations and advertisements should be made accessible to media. So we're noting that because already the bill provides for those media platforms that may be used in terms of the advertisements of invitation for nominations. So they are saying also individuals to be appointed prior to appointment must be subjected to vetting and screening process, which we supported, and we have coined that a specific clause to also include that before the minister recommend those people to be appointed, must also do so after having complied with the vetting and screening process. Factors to be considered, to be taken into consideration, there's a comment that we need to also take, the bill need to also take into account the geographic, economic, and social factors, which is already catered for in clause 24 of the bill. So they're saying the appeals authority must be accessible and their contacts thereof, so we're saying this is a matter for consideration in the regulations. And the board can also, even now, they do provide those details through their website. Delimitation of ward process of 10 years, which I dealt with later in the preceding slides. So the other matter is just general, that the board must be enabled to establish provincial offices and provincial representatives thereof. This is already catered for in the bill, because the bill as it stands now, it provides for the board to determine its own staff establishment, including the appointment and approval of staff establishment and appointment of those specific officials to serve in those positions, and to also acquire the property or ownership based on the having, of course, due regard to the availability of funds to establish those and acquire those properties where necessary. So Western Cape provided also as well some comments, and the 10-year interval, most of these I've dealt with later previously while we were clarifying the issue of transitional grant, which is already there, and the strengthening of communication and consultation, which the bill seeks to resolve as well. It has been dealt with quite a lot in the bill. So they're saying the definition of president, it need to be clearly provided for in the bill, and of which, of course, we did support that and made it clear that the president would mean the head of state and the head of the national executive as contemplated in section 83A of the Constitution. So the composition of the board, there was also an emphasis on the gender, so it's something that we have indicated that can be dealt with, considered by the selection panel through the decision-making processes. The responsibilities of the board, I've dealt with this previously, that the status as provided for is not questionable, since it is providing for the board to be independent, impartial, and perform its functions without fear or favor or prejudice. And the issue about qualifications, they indicated that they recommended that this be amended to include persons that hold a position in a political party. And so this is not supported because the bill already covers these positions within in the bill. It defines the political office in terms of who are those that are being referred to be holding that political office in the definition. That will be a deputy secretary and other treasurer and other positions, given the nature of the board, to avoid political expediency. Appointment of board members, there was a comment as well that the selection panel contemplated, as I indicated, may present a potential political influence, which we don't agree on the basis that it does also include the chairperson, the Chief Justice or his designee, the judiciary as part of the other members of the judiciary as part of the selection panel. So it goes beyond inclusion of the MPs. So the other issue is still the same, related. So the term of office, one other comment came out of that, that members of the board are appointed on a part-time basis except for the chairperson, whose appointment may either be full-time or part-time. So they're saying by virtue of how it's provided for there, the chairperson is a member of the board, and therefore, in terms of the former, he or she will be part-time. Hence, there is no need to repeat that the chairperson may be part-time. So that being noted, and the response is that it needs to provide for the legislative drafters to see to it in terms of how that can be reviewed. So committees, this one we've dealt with previously, and yes, of course, we dealt with that one, and the limit we've dealt with that one. The CEO, so they're saying the clause refers to seconded. However, there is no reference to legal authorization in terms of such secondment. So they're saying that the PAMA is an example, and a definition can be incorporated under this specific bill. And we're saying that is noted the conditions of services of employment of employees, including secondment, are already provided for in the bill and is already aligned to PAMA. Factors to be taken into account, those are those issues that they felt we need to also include the bulk water services and catchment and other related factors, which we are saying they are broadly covered in section 23 and 24 of the bill. Determination of category of municipality, there was also a comment around that, and that being noted as well, and something that can be considered for inclusion in the regulations. 10-year cycle, we dealt with that. Public consultative meetings, the bill that is supported, the bill deals much more in terms of maximization of the means for community participation. Then the other issue is around using may in exceptional cases. This is not supported for the reason that the minister may either decide on a different or a shorter period only on exceptional cases for those specific determination. Public participation, we've dealt much with that. So they're saying it is suggested that the current appointment process of appeals authorities is inadequate, and the present manager is just empowered to draw up a list of names to the president. So they recommend that a more comprehensive appointment and interview procedure is preferable, which is noted, and that as well, even as it stands now, the minister does so through the request for nominations, and the interviews process are being followed in that aspect. Transitional arrangement measures, what they are saying there is that it will not be possible to perform any functions or give any effect to the Demarcation Act, as the intention of the bill is to repeal and replace as contained in the schedule. So we're saying some of these may be detailed more into the transitional arrangement measures in terms of how specific provisions can be implemented. So this proposal came from Limpopo. They're saying we must keep the regional diversity. And it's not supported, and there was a proposal from the portfolio committee that we change it to say broadly reflect the composition as opposed to reflect the broad composition. Other issue that came out from Limpopo is to ensure that the national and provincial houses designated by chairperson must be included in the board as an ex officio instead of being part of the selection panel. So we're saying that that is not supported for the reason that the inclusion of members of a national and provincial house might impede or compromise the status of the authority as provided for in clause 4, which requires the board to perform their functions without fear, favor, or prejudice. Delimitation of wards, process, they're talking about the inclusion of traditional councils, and we have said this, the bill provide an ample provision for consultation with those traditional and coastal leaders at all levels. Appeals Authority, they are proposing that over and above any person who must also include persons. Here it relates to those persons that may be aggrieved. So at point it may not be a person, it could be a group of people or civil society organization, whatever case may be. So to refer to it as a group of persons as well, to cover that aspect, which is supported, and indeed we proposing that it be crafted as provided in 4. So that marks the end of the presentation, Chairperson. These are the specific recommendations that we're making, is that the committee note the content of the presentation and the responses that we have received as submitted by the provincial legislatures, and to also note that this bill has been now translated to 2 so far official languages, isiZulu and isiNdebele. And to also bring to the attention of the committee that given the contentious nature of the demarcation related processes, we have engaged as well the Office of the State Law Advisor to translate this specific bill in all 9 official languages. So that this process is underway, and we're hoping to get that as soon as possible. Thank you.
Thank you. That was a detailed response from all the provinces, with the exception of the Eastern Cape, which is the matter that is before this committee to look at. Thank you very much. Are there any additions from the team?
Chair, just from the MDB side, it's a humble request, and having heard the legal advisor earlier on, that it's actually the discretion of this committee to consider the work done, which is over 80% already done. It would be good if you do not restart the process and then you align yourself with the LGE 2026, because if you are going to restart, it might also have a direct impact there. That's just my humble, just consider that as well. Thank you, Chair.
It's a fair submission, but we look at it. Like you have responded to the provinces. You said noted, or you said rejected. So we are going to consider it. Thank you. It's a fair submission. Members, it's now your opportune time to engage. We have requested the team that they must open the aircon. It became a crematoria instead of being the boardroom or the venue for the meeting. Honorable Parent Host, you are the first. I'm noting members, please, there will be no afterthoughts. Honorable Konza, you are the second. Honorable Nkosi, you are the third. Honorable Eza, you are the fourth. Honorable Briet, you are the fifth. Chair, Free State, Northern Cape, yes, you are 7. Honorable Nzimande, okay. Honorable Nzimande, you are 7, then you are 8. Honorable Makasin, Valimbogot. Okay, can we, on this side, my chair from the province, Honorable Ne, you are also number 9. Let's go in that order, colleagues.
Thank you, Honourable Chair. Gentleman that spoke last from the department, what is your name?
It's Manye Moroka, the CEO of the MDB.
Sir, I would like to remind you in future, please don't prescribe to a committee what they should decide and not decide on, if you don't mind. We are elected by people to represent them in this house, and so we have to make a decision based on what their interests are, not what the department's interest is. Thank you. Honourable Chair, having said that, I've explained earlier that we have a problem here in the sense that, first of all, the public participation process for this bill was not properly done. I'll give you an example, and I see it has been left out of the presentation of the department. The Western Cape had a procedural comment as well as to comments on the different clauses. And that procedural comment was omitted from their presentation, where they said, the Western Cape Provincial Parliament Standing Committee on Local Government wishes to express its grave concern about the fact that inadequate timelines effectively deny the provinces and their residents their constitutional right to meaningful participation in the legislative process. Due to the prior parliamentary commitments and the fact that the briefing to the NCOP Select Committee only took place on the 7th of February 2024, the committee could only be briefed on the bill on the 13th of February, with the deadline, very important this, for negotiating mandates initially scheduled for 27th February. The committee wrote to stakeholders and made use of social media to solicit public comments on the bill. That's how we got to a lot of our comments. However, to ensure proper public participation, the bill should have been advertised for at least 2 to 3 weeks before proceeding with the public hearings. As the bill, and this is really important, has a direct impact on municipalities, and given the nature, scope, and possible impact of the bill, it would have most likely have required the committee to hold public hearings in at least each of the municipal districts of the Western Cape. The NCOP is aware that the Legislatures committees are already processing several bills in addition to their own provincial work, and the committee is concerned that some legislatures may not have had the capacity to process the bill under these strict timelines, which does not provide much room for public participation. I would then like to refer you, Honourable Chair, to Doctors for Life, and I think the Mogale case also stated that there must be a reasonable opportunity for public participation. So in our rules, if I may just refer you to our own rules in the NCOP, Rule 219 refers to the legislative cycle. And if I may read, all sections of the bills, and that mentions the bills, section 76, 3, 4, 5, 74, 1 and 2, and 3, must be dealt with in a manner that will ensure that provincial legislatures have sufficient time to consider the bill, facilitate public involvement in the processing of the bill, and confer authority on the provincial delegation to negotiate and vote on the bill. Subsection 2, depending on the substance of the bill, the period for the consideration of the bill is at least 8 weeks. Number 3, in the event that the substance of the bill requires more than an 8-week period, the chairperson of the council may, at the request of the chairperson of the relevant committee or speaker of a provincial legislature, extend the period. And this is really important, Chair, because that request was made at the time. It was made in writing in the letter that I referred to earlier on the 15th of February to the chairperson of the National Council of Provinces. And that letter was ignored. So just based on that, this process is flawed. And it's my submission that we need to start this process over again. Because should this bill go through our house now, even if we start the public participation process all over again, should this bill be processed, it's going to be challenged in court based on the process that wasn't followed when the bill was, the 80% of the work was done. So my submission is that this bill needs to be referred back. Thank you, Chair.
Thank you. Honourable Konza.
Thank you, Chair. Greetings again to the House. Chair, I do think that when you were responding to why the Eastern Cape is not on the listed provinces, you slightly touched on what I was going to say in relation as to the problems that then faced the Eastern Cape at the time, especially around enough time for public participation and the scatteredness of the province in relation to us being able, then as the previous committee, to touch everybody that was to be touched in relation to this, especially with the Lamusa judgment and other issues of public participation. But also to raise, Chair, that whether the select committee decides to not start the process afresh, the Eastern Cape therefore makes a presentation and request that we be afforded an opportunity so that when the final bill is out, the people of the Eastern Cape can be able to have a stake and ownership on the bill. I just also want to say, Chair, that even when we were given the extension time, which we received on the 19th of March, by that time, the select committee had already dealt with the negotiating mandates. But even the advice that we got from the procedural officer that we need only to look at the final, we need to look and submit the final mandate, was legally not going to be compliant with the legislation, because we would not have participated in the negotiating mandate phase. And also it would have meant that the participation process of the communities would have, or stakeholders would have been compromised. So therefore we feel, Chair, and the House, that we need to be given that space so that as the Eastern Cape, we can be able to deal with the process. We understand, Chair, that there might be pressures of time, but we are at the mercy of the committee to give us whatever new process plan in relation to us is concerned, and we undertake then that we will comply with that. Thank you very much, Chair.
Thank you. Honorable Nkosi.
Thank you very much, Chairperson. Ours as Mpumalanga Provincial Legislature, we have done everything on the bill. We have followed all the processes. In fact, you'll remember that if it was not the end of the 6th administration, we would have submitted all the final, even the final mandate. I therefore propose that maybe let me put the view of the Mpumalanga Provincial Legislature that let us continue with the bill, because starting it afresh to us, it will no longer be consistent with our rules and orders, because we have exhausted everything that was expected from us. Thank you very much, Chair.
Thank you. The next member was Honorable Eza.
No, thank you very much, Chairperson. My worry is that yeah, yeah, it's the rising sun that does so. We are in a different period of governance, coalition. And therefore, we have to be alive to that this process, perhaps if it affected the Eastern Cape, then we should then give a chance to the Eastern Cape, but give the chance to the Eastern Cape in terms of the rules of the NCOP, because I don't think that it's sufficient enough, the period that provinces are given, because the rules then provide for 8 weeks, and then you find that they have 3 weeks to submit and complete and engage. The other issue that I had, Dr. Naidu, you'd remember in the committee that people with visual impairment, apart from the fact that there is an audio to rely on as contingents, you'd find that 170 of those people are affected because there is a question of hearing and impairment of visual as well. So one of the things that we raised then was the issue of Braille, that is provided in the public hearing processes, and therefore the maximal participation that we got then from these 170,000 people that are affected, that could not maximally participate into the process was not sufficient. I mean, even today they feel like that we were not taken into account because there's not enough. If there is anything, the political office will just go and get the ward committees and fill the hall and so on, without these vulnerable people. And the other issue that we raised was the issue of the devolution of the Demarcation Board for easy access and dispute management at the time, and I didn't see it expressing itself here because you can't sit in Johannesburg and draw a demarcation that affects people or affect even a house. It cuts the house into half, and the other traditional communities on the left of the house, and the other is on the right. So we seek to correct those things and make sure that there's maximal participation into those issues. And at clause 10, which does not leave much room for the appointment of independent members of the board, for the selection panel, save for the appointment of the Constitutional Court judge designated by the Chief Justice and the appointment of the chairperson of the Commission of Gender Equality. All other appointments are laced with political connotations. So some of the issues that we had at the time were pertaining to that, and we would have loved at least for you to say it's not supported, but not for it to be non-existent in terms of what we said there, because I saw in clause 33 of the Free State that matter was being repeated there, right? And for a more accountable and open and accountable process, perhaps Parliament is the most suitable institution to conduct the selection process for the appointment of the board, not a selection panel. We also suggested that a transparent and public process of the nomination and interview process to be followed. So those are some of the things that we dealt with, but not to see them being there but not supported. It's better than not being there at all, or not being considered at all. Therefore, we would require a prompt indulgence into the issues that we raised and into the processes, because I was part of that team that went across the provinces. And when we came to Western Cape, I think we went to Brankeveld and Kwalang. There was no one in the hall. It was a complete flop in the Western Cape. We came twice, and it was a complete flop. It's almost like somebody said, don't attend.
So Honorable Baden was did not organize.
Yes. So there was no one at all. I mean, it's on record that we went there, but there was no one. It was zero. There was no participation. So ordinarily, Chair, you would find people that are past, and then you would find that people, in terms of the diversity across the youth, women, people with disabilities, all vulnerable groups are together. Then you complain based on the people that are past, but not to have even a single person. It leaves a lot to be desired. And then, please let's support the Eastern Cape. Let's give them time, but let's give them time in terms of the rules of the NSOP, and so forth. And yes, Chair, I think those are my submissions.
Thank you, Honorable Nzimande. Or was it Honorable Priet? Yeah, before you. Then Honorable Yobet, then is the next, then you follow. Ungisabise ngebala nje Nzimande.
Thank you, Chairperson. No, Chairperson, I think valid points have been made by my fighter here who's just left, and Honourable Badenhorst, and the Chairperson from the Eastern Cape. And the fact of the matter is that public participation in our provinces was lacking. Yes, due to the fact, and we can see it there, that on the background, the roadmap, NCOP deferred the bill to provinces on the 7th of Feb, and the 8th of March, the Select Committee had to deal with the negotiating mandates, which gives them, weekends included, less than a month to having to deal with it. It was so bad, and I'm from the Free State, that the Free State Legislature, which has 30 members, had to split into 2 groups, so 15 each, and then they had to, within their select committees, then deal with bills. So that gives you 2 or 3 members in a committee having to deal with bills. Realistically speaking, we cannot sit here and say to each other that that is enough members to make an input, to work on a bill, to give a negotiating mandate to provinces. That's the first point. That to me is, and I am sure that if we go to the Northern Cape, which also has 30 members, if you go to Mpumalanga, who has 48 members, you would see that that is the exact same problem. We have had judgments. I was in the previous parliament, I was in the NA. We had bills referred back to us that were declared unconstitutional because public participation was lacking. As Honourable Kleza has just said, they had 2 public participations for the NA in the Western Cape, and it was a flop, were his words, because there were no people. So if we just look at that, it is insufficient. Then furthermore, taking this into account and the importance of municipal demarcation and what we've seen in the history, and we can have long discussions about municipal demarcation. Just during the latest process of the municipal demarcation, I'm very unhappy with how procedures happened, but that did daar gelaat. In the Free State, we did not even go to the metro. Mangaung was not even one of the public participation hubs. Then I go to the Northern Cape, and they have 6 districts. They only went to 4 districts. And literally, it's pits onder water, which has like 10 people in. So public participation was not done correctly. To take that into account, that's an extreme worry to me. That how did we get to these negotiating mandates? And then, furthermore, taking into account the Eastern Cape has not submitted because they said the time allocated was too short, and they even got an extension to it, which then I might add is unfair because only Limpopo and Eastern Cape got extensions. None of the other provinces got extensions. So they weren't granted an opportunity to further do public participation correctly. And then my problem comes in. I agree with what the members have said and with the chairperson of the Eastern Cape. We should allow the Eastern Cape an opportunity because they're one of the provinces. They are one of the provinces that will also be affected by municipal demarcation, and largely so in Gqeberha and, Bisho, and how people have expanded. So give them an opportunity. But then my plight is, it is unfair to only give them an opportunity this part round, because we have gone through a national election. We have new governments at play in every province, and this is my plight and my plea to you. If you then make it open to Eastern Cape, all other provinces should be taken into account, because the 7th Parliament and the 7th Legislatures and the 7th Administration is vastly different than the 6th Administration was. So to give one an opportunity and not the rest would be unfair. But then it begs my question, and I'm sorry that the lady of Legal Services has left, because my understanding, Chairperson, is that these negotiating mandates that we've just dealt with, nowhere, yes, we as the NCOP revived this bill. but none of the 7th legislatures revised or what's the word I'm looking for, revived their negotiating mandates. And as I've just made the point, our administrations have changed. So negotiating mandates can change. Their opinions on this bill might change. So who gives us the right to deal with negotiating mandates of the 6th Parliament when 7th Parliament and 7th administration is different? And I think that needs to, and that is one big critical issue to me, is because we're different, it's different administrations. This is, the gentleman from the MDB, the CEO, said it is crucial that we do this. We agree. It is crucial to get an independent demarcation board there. But we cannot, because of LGE 2026, be faltering and not do a process efficiently, because as I think it was Honourable Badenhor said, we are opening ourselves up to legislative issues, to constitutional mandates, to lawsuits. And frankly, we are currently one of the environmental organizations, or I think it was a wildlife organization, is taking the NCOP to court because of public participation and because of the manner in which our provinces did not handle it. So this is not a box-ticking exercise that we can just do and finish it for the sake of in time for LGE 2026, because the repercussions of that is going to be so bad. And then, can you just think, we go into a court of law because of this. Then we've now forced through this bill, we've forced through LGE 2026, and then LGE 2026 gets called null and void. And then we need to start LGE 2026 again. And then we need to spend money on that again. And then the process needs to start again. And then we are fighting elections and not going to serve the people. And that, frankly, I don't know about you, is not something I want to do. And then lastly, Chair, if you would allow me, a lot of mention was made on not having political interference. A lot has been said. I think it was the gentleman that said we need to ensure that it is free from political involvement. But the bill as it currently stands is not free from political involvement, because the proposed selection of the selection panel is a person with specific knowledge of demarcation designated by the minister after consultation with MECs for local government, political appointments. Chairperson of the Portfolio Committee in the National Assembly, responsible for local government, a political appointment. Chairperson of the Select Committee in the National Council of Provinces, responsible for local government, a political appointment. Chairperson of the National House or a member of the National House. I think the department itself said that is not free from involvement. You will not be able to do it with fear or favor. And Chairperson, based on that, we need to have a rethink about this. We need to have this committee, who I think you've seen are, I don't want to say rambunctious, but my English is faltering me, but robust, that's the word I'm looking for. But we are robust in that we want to serve the people. We were in Tabazimbi during our constituency period because we felt the need. We had to get there and to see what was happening. So, Chairperson, I would really like to plead with you, and I would like to emphasize and second what my previous members have said. We need to refer this bill. We cannot deal with it. We cannot just give exception to the Eastern Cape. We need to start afresh. Thank you.
Thank you. Honourable Yobert.
Thank you, Chair. I think I will repeat most of what was said already, but I think also it is very necessary to put it on record. I've got a grave concern, basically three, and the previous speaker also referred to it, is the composition of the 7th legislature as well as Parliament. It's totally different from the 6th legislature, which means that how can we now simply accept that the current legislature will agree with the mandates given by the 6th legislature. That's a grave concern because views differ, inputs will differ, and we cannot carry on without without giving the 7th legislature the same opportunity of input on this bill as the 6th. Then my second concern is, I received a mandate this morning via WhatsApp, our mandate. I am the only member and I sit on all committees. This mandate was never, through any process, approved or condoned by our legislature. So how can I support this here without my legislature telling me they support this? And I don't know whether the other provinces sit with the same issue, because I don't think if they also adopted the previous legislature's mandate, that they can now continue on that mandate. Then, according to this mandate I received, well, as my colleague also said, we only had participation in 4 of our districts. 2 were left out. According to this mandate that I received, there were complaints by the public because they could not partake in this whole process. Regardless of this, according to this mandate, we should support the bill. How can I or my committee, with those complaints, agree with that mandate? And I assure you, even the legislature, currently as it is, will concur with me that we cannot concur with or support the mandate as it was given to me this morning. Not even yesterday or the day before, so that I can discuss it with some people, the Speaker, or the Premier for that matter. That even, I was even not given that opportunity to get their input on this. Therefore, Honourable Chair, I would also recommend that this bill be referred back and start from scratch. I thank you.
Thank you. Honourable Nzimande.
The nice part about me, Chair, is that I'm from Gauteng. And as I'm from Gauteng, Gauteng has been addressed in terms of whatever they submitted. We are just noting what is brought before this House as a response to Gauteng, as a permanent delegate. We're not committing on anything, but obviously, now, as a member of Umkhonto Wesizwe, I'm very much impressed by what is happening to Grand Coalition. I'm very impressed. As a member of Umkhonto, obviously, we take notice of the clarity that is provided in terms of Chief Executive Officer and the Executive Officer. I guess that clarifies. But furthermore, we believe, because the dynamics down there will be different. Maybe the provisions are not enough to cater for different probably matters that may lead to conflict. Maybe we need to strengthen the area about consultation at that level. But Chair, I guess on a broad perspective for the bill, it will assist. I wish I can apply so that I deal with Western Cape issues and Eastern Cape. That is on a lighter note. But, Chair, the last part we needed just to check. Did you leave it deliberately on definition, the issue of suitable qualified person? Because it's not defined. I can see what is in section 9, but that concept has to be defined proper. What do you mean about suitable qualified person? No, thank you. Good luck to JNU. But what we want to suggest, Chair, we can't wait even for Eastern Cape. We can't. They were given a clear timelines. They did not honor, irrespective of the reason they presented. Even today, we are sitting with no clear extension that was further given. That is just open-ended. Whether you are guilty of having not given a precise timelines is something else. I guess the purpose and the intention of the bill should rise above the narrow party interest. We must address the issues of the country. We are legislatures. Thank you.
The next member is Honorable Makesini, followed by Honorable Ne and Honorable Peter.
No, thank you, Chairperson. Let me welcome the presentation of the bill. You know, the issue of the Eastern Cape, I want to start on it. If the consultant, regardless of they were given extension on what, but if the public participation didn't happen to Eastern Cape, we cannot support anything that we don't have Eastern Cape. Based on the challenges of the Eastern Cape, I would request, as Honorable Gcilza was saying, let's give extension the Eastern Cape an opportunity, but they must stick according to the rules. Because of the dynamic, they cannot punish this 7 administration because of the failure of the 6 administration. What we are representing here are the people. So the interest of the people and the voice of the people of the Eastern Cape will need to be given an opportunity. So, Chair, you'll consider how you make it, but the Eastern Cape, it needs to be given an opportunity and you need to monitor. I'm also worried by the Western Cape. If consultation was not done, and Honorable Batinos is raising the issue of the liquidation and everything, legal processes, you must not take it light. Because if the public participation in Western Cape didn't happen, again, this thing will gonna give us a problem. So, as much as we are giving these 2 provinces an opportunity, we will check with the delegation of all the provinces, what is it that we didn't do that we want to be given an opportunity. So that by the time these 2 provinces are doing maybe consultation further to 2 certain regions in Northern Cape and Free State and other sectors that were not consulted, we can give them an opportunity. Because we really, the issue of the minister who have to, the president will have to appoint and nominate the people that are participating because of the recommendation of the panel. Then the same minister is the one who's going to do the oversight. I think the process also, Chair, we must be given to Parliament so that the issue of the transparent is fair for the people who are staying in the board. I don't also agree with the issue of clause 26 of Gauteng of 10 years because of the challenges that they face of finances and everything. The 5 years is enough. People, they must learn to work with what they have. They must plan according, and they must bring these offices of the Demarcation Board closer to the people, because these offices, they are in Pretoria. They are not in our provinces. A person who never knew Velcom, uthi ndihlala eWard 33, ndilapha indlu yami enye kwesizilalini. Indlu yami like ezilalini, you can see there's a house here, there's another house. Kufika umuntu wenza umgca kwami asixabanise. Athi utata uzawulala ngapha, athi umama uzawulala ngapha. Ichitha imizi le nto demarcation. Iward mayidibanise ingachithi ubukhosi, ifumane kuthiwa inkosi certain chief ihlala apha but another part ayabantu bakhe ikwenye indawo, so that they must consult with the municipalities and work very closer with the municipality. So I think because of the opportunity sifumene a weakness as a Eastern Cape, let's just open it, but we must monitor the process. Si checkile I request ka chairperson or CFO we board ukuthi we must never forget ukuthi siya kwi local government election and time is against us. I fully agree with him, but let's give opportunity to the Eastern Cape. La province siyayifuna and we can't left Eastern Cape behind. Thank you,
Ifuna
Chairperson.
ningobani?
Sifuna singo progressive.
Yabona-ke manje,
caucus.
yabona-ke manje usufaka izinto eziningi uzongakutholeli lokho-ke. Okay, Honorable Ne?
Thank you, Chairperson. I'm largely covered by the comments from honorable members, and I share their sentiments. But from KZN's point of view, I'm told that during that period, it was a very rushed period. The province was inundated with a large number of NCOP bills and had to rush through the process in 4 weeks rather than the stipulated 8-week cycle. There were 3 public participation engagements, 2 physical and 1 online. But the most concerning part is that this bill was not presented to the traditional leaders, which is very crucial in KZN. And so, therefore, I'd like to recommend that we do justice to this bill by starting from scratch and get the views of the people, get the accurate views of the people, and perhaps these mandates will be changed. Thank you.
Thank you. Honorable Peter?
Thank you so much. Chair, Umama has covered me because I was to touch on the traditional leaders. So you touch on it, but I just want to say to the committee that is in front of us, the department that is in front of us, my appeal to you, the department, once you touch the land of Madiba, Eastern Cape, and you touch the land of Desmond Tutu, Western Cape, you touch the problem. Look at now, 8 provinces, they are against you, meaning you touch the wrong land. So my appeal to you, honorable members, I respect you because we have taught to respect human beings. But there's a principle that says, a Bantu Pili principle. The principle that says the people first. Once you are in a rush when you are doing things, because you must know you are the government that doesn't care for people. You must care for the people. Whatever, there are a lot of discrepancies, but you must take care. But because of the other provinces, Mama, they've just made an appeal for this department to take care of us as the Eastern Cape. I suggest to you to welcome Eastern Cape as one of the part. I'm not enforcing you because the province has spoken. It's just my word that say Eastern Cape, don't touch it again. If it's not there, nothing would happen.
Yeah, the meeting is still going to make its own determination. But thank you very much, honorable members. I think we have covered all of you in terms of the hands that were raised. If we do not conclude this before December, how is it going to affect the local government election? Because my understanding is that as you are dealing with amendments, that will mean you'll have to use the old law to prepare for local government elections. It doesn't mean that the process is going to come to an end. But the sentiments raised by members, I think they are genuine, justified. Even Pumalanga, they raise a justified point that we ran a process, we spend people's money, so we feel, and Gauteng, we feel that that will be a wastage if you say you must undo. But if you consider extending for all provinces that feels that they still want to further consult, then that process will accommodate everybody. So I think those were the sentiments, but there was a sentiment which also was strong that let us rerun the process. So, but let me allow you to respond, Doctor and CEO. Then we'll summarize on the way forward.
Thank you very much, Honorable Chairperson, and the honorable members for the inputs. I think largely most of them were comments, but there were specific issues that I feel that I need to respond to. And I think the first thing is perhaps to deal with the issue of the selection panel and the possible political connotations attached to that. You know, I've had the privilege of having been Honorable Chairperson, part of the very first panel chaired by the late Pius Langa. I've been part of the panel that was chaired by Justice Jaskelson, sorry, not Jaskelson, Moseneke. And more recently, I've been part of the panel, the last one, that was chaired by Chief Justice, I just cannot recall her name. And the process that is followed in that selection panel is of a very professional, dignified process, and I see the one member smiling. As part of the panel, we have a judge from the Supreme Court, and the oversight that is provided in that committee is beyond reproach, and I can vouch for the sincerity and the openness in which that process is undertaken. So we have the Commission on the Gender Equality there, a representative from SALGA, from the department. So whether there is political connotations there, I haven't seen it, and therefore the view that we have put forth in terms of the way that selection process should proceed with has been carried through in the bill that we have presently. Now, the point made by Honorable Xeza around the different government that we have, the government of national unity, and I think with that comes different combinations in terms of what would be in the selection panel as well, and maybe the members of the board, because with the changes that we have seen, we probably would have a person on the panel from a different political party as a representative from the select committee or from the National Assembly. So that oversight is also carried through there. The point you make specifically, Honorable Xeza, about the visually impaired, if you look at section 39(7)(a) of the bill, where we say that for those persons that cannot write and for those persons that are deaf, special provisions could be made to assist them. And perhaps what we could provide for is the very specific point you made around visually impaired. But you can see, Honorable Xeza, that dealing with persons with disabilities is something that we have tried to carry forward in the bill. The issue around devolution or decentralization of the demarcation board offices, I don't think it is a matter for the bill per se. It is something that we have been engaging with National Treasury for a long time. And with decentralization will come a lot of cost implications, but there were various options that we had put to the Treasury in terms of perhaps not having a office for a province, but you could probably cluster provinces, perhaps 3 together, and have a decentralized office that would service 3 provinces. But we had engaged them and put those options to the National Treasury. So when you look at the bill, the common thread that flows through the entire bill is trying to upscale or to take public consultation to another level. So presently you would have, for example, around ward delimitation, a no requirement as such for the board to undertake public consultation deeply. But when you look at the bill now, the bill says that when it comes to outer boundary demarcation, you need to send out an investigation team to look at things. They would need to put a report, bring it to the board, and then the board would undertake a detailed consultation in the various areas. That entire process is also mirrored when it comes to ward delimitation. So they go out in the first instance, public consultation very deeply to deal with outer boundary demarcation, come back, when it comes to ward delimitation again, that entire intensive process around public consultation. So for us, that is something that we've really elevated, and mostly because of jurisprudence, notably the Matatiele case, where public consultation was found wanting, and therefore the Constitutional Court at the time dealt with the demarcation of Matatiele in the manner that it had done so. So public consultation, Honorable Treza, is deeply entwined in the legislation. Perhaps to talk about the implications for the local government elections, and I take the point from Honorable Badenhorst and us not to nudge in a certain direction. Chair, the one provision that comes to mind that would be of importance for the next local government elections would be the point where we put in the bill the deviation of 30%. So you would know that now, presently the norm in a municipality may not differ by more than 15%, meaning that each ward in a municipality cannot have upwards or lowers of 15% difference in terms of the norm. In the bill, we have said that in certain instances, the deviation by the demarcation board when delimiting wards could be 30%. And this is to ensure that you do not have split communities, split traditional leaders, or persons living on either side of a mountain to form part of a ward. So that for me is the most notable intervention that we would have liked to have in place when the board undertakes the ward delimitation. You are right, Chair, that if the bill is not in place timeously, the prevailing legislation will have to be in effect when it deals with the ward delimitation process, which the board is undertaking now. And look, we've had it in place ever since 1999, so, you know, it's legislation that the board will have to deal with. Honorable Chair, I think those were the pertinent issues that I felt needed to be responded to. The rest was debate around a full consultation process or a limited consultation process limited to the Eastern Cape. I'll stop there, Chairperson. Thank you.
Any CEO, any further additions?
I think I'm covered, Chair. Suffice to say, in the bill itself, they refer to satellite offices, or what we call the offices, to be set up so that the MDB can be nearer to the people. Now, if an act has been promulgated, an act is costed, so there'll be a cost implication from the side of, so that's the only addition that I wanted to make. Thanks, Chair. But the DDG covered everything. Thanks.
Thank you very much. Honourable members, I do not think that we need to vote on this matter. I think all the submissions requires that we make our determination having consulted. I think we still need to check the legalities. Unfortunately, the legal advisor is no longer here. Then the committee will have to meet when we do our oversight and take a decision on the matter. We'll have sourced the legal advice by then. Then we'll make provinces aware of what is our decision in this regard. But we wish to thank the department for having presented before us, and we've considered all the presentations, and we've also considered the submissions by provinces and honorable members of the NCOP. So we'll make our determination and we'll make you aware of what is the next step. But thank you very much for having taken your Friday to come here. I know it's difficult Fridays to come to Cape Town, but we really thank you and commend you for your action. And we wish to thank our officials as well for having arranged everything for us to have this engagement. With that, honorable members, I would like to remind you, NCOP members, that the following week, on the 21st, you are being consulted at the moment. We had a meeting with Chair of Infrastructure, Honorable Badenhorst, earlier on today. So we have put together the oversight plan that will include the two committees, because we are members in both committees. So it will be prudent that we do oversight in the same place, in the same province, instead of dividing you into two groups. So the first oversight will be on the section 1391B in the two municipalities, Zululand and Mzumbe in KZN. We'll conduct those two oversight over 2 days. That will be the 22nd and the 23rd. Then on the 24th and the 25th, we'll proceed even in the afternoon of Wednesday with Oku District over the Infrastructure Department to look at the projects that are around Umdoni, Mzumbe. Then on Friday, we go to eThekwini to look at the CoGTA project, and then we'll conclude our oversight. So this is how. Oh, then the harbour, yes, I said at the port. We'll go to the port as well. So to look at the progress that is being made, not on the privatization, but on the integration of the private sector in that port. So we'll be assessing the progress that is being made by GNU there. So that's how our oversight will be unfolding in the following week. Any announcement?
I think sure we have covered it.
Yes. Thank you very much for your time, and have a nice weekend. All of you have a safe journey back home, those who are traveling. Thank you very much. The meeting is adjourned.